Please continue.
Of course. Thank you, my lord. All right. So I was still dealing with the first ground, and so what I'm going to do is finish my submissions on ground one, which is the agency point. I won't go back over what I said yesterday, but just to remind you of where I got to. As we understand the case, it is now put as one of implied actual authority. So what is being said is that the authority that's required to make these statements and make this demand arises out of something. It's implied. There needs to be something that you imply it from. What is it that gives rise to that implication? It is said, well, it is because Noor Bank was spearheading, is the word that was used, the negotiations, but the go-between in the negotiations between the group and the bank. And my first point was, well, that's an incident of Noor's role as arranging bank, and you cannot imply any agency as between the arranging bank and the lenders as a result. If the allegation is that there was some other role, some other sort of arrangement going on, firstly, there's no actual allegation of the facts giving rise to such arrangement. But even if there was, it would take my learned friend's case no further, because if it's being said there was some specific arrangement between those individual banks and Noor, appointing Noor to negotiate on their behalf with the borrower, then it wouldn't cover the sorts of assertions and demands that are being alleged. Because if I appoint someone to go to a bank and negotiate for me, I don't authorize them to negotiate on their own behalf for me. And that's the substance of what's being alleged. Noor is negotiating the terms on which it will join the facility. Now, what my learned friend then says is, well, because Noor was in that role, that might give the opportunity for some further authority to arise. But that would need to be an allegation of express actual authority. In other words, that the bank had expressly, or the banks who are thinking about joining the syndicate, had expressly said to Noor, these are the things you can communicate on my behalf. That is not alleged. And it's not enough to say it might emerge from the documents. You need a positive case. The second problem is, assume that Noor was somehow an agent as a result of this role. You have to ask, what would they be an agent to do? And as I say, that would be to negotiate on behalf of the individual banks, if that was what they were appointed to do. So it brings everything back to the fundamental strangeness, we say, of what is being alleged. If one looks at the threat, this group of banks, because they're not a syndicate yet, they were on the case authorizing Noor to demand additional security for itself. On the promise, they were authorizing Noor to make promises on its own behalf in a way which somehow makes the banks responsible for that promise. In effect, they're saying Noor's gone into that meeting, firstly to say, I'll ask the banks whether or not they'll contribute further working capital. If they don't, I will give you that working capital. But also there needs to be another bit, which is, and the banks underwrite my guarantee. The banks are contractually responsible for my guarantee, which is inconsistent with the case, which is that they didn't know at that stage. No one's saying Noor was suggesting that there was a commitment from the syndicate to give working capital. They said, we'll try and get it from the syndicate on this hypothesis. If we don't get it, we, Noor Bank, will guarantee it. So there's no commitment on behalf of the syndicate that's being alleged. Now, in the appeal, the argument that my learned friend gave you yesterday does a real disservice to the judge and the judgment. It really mischaracterizes actually the way in which the issues were decided, because this is what you were told. You were told that the judge's reasoning was this. Firstly, that Noor Bank was acting as the defendant's agent at the Palm meeting as a result of this IMLA letter. And therefore, Norbank could not have been acting as the agent for the syndicate. And so what my learned friend said was, well, that's wrong, because if Norbank was negotiating with the borrower, it couldn't have been the agent of the borrower, and therefore it all falls apart. But that's not the logic of the judge's decision. The reason the judge was dealing with the IMLA letter at all was because that was the way the defendants had put their case below. The way they put their case below was they said, firstly, the claimants haven't adduced any direct evidence on agency. The only evidence comes from the chairman, Mr. Al-Mahari. And he said in his written witness statement that he believed that the effect of Norbank's appointment as arranging bank under the IMLA letter was that Norbank had been appointed to represent the banks. So he gave his subjective explanation of what he understood was the effect of the IMLA letter, that it somehow appointed Norbank for the other banks. And that was the claimant's, the defendant's case on agency below, that it emerged from the appointment as lead arranger. And so that the judge's point, when he dealt with it in the judgment, was that Mr. Al-Mahari's subjective belief that there was an agency relationship was completely irrelevant. And when you look at the IMLA letter, the effect of that letter could not have been to appoint the arranging bank, Norbank, on behalf of the lenders. It appointed them as arranger on behalf of the borrowers. So the effect of that was the only agency relationship that you get from the IMLA letter is that Norbank being the agent for the defendants for the purposes of putting the syndicate together. That's the effect of his judgment. I'll show you that very briefly. It's at bundle B, page 13, behind tab 1.
Can you remind me whether the prospective lenders had been identified at that point, or was it still open that there might be others?
Yeah, there was. This is on the date of the December meeting.
Oh, the date of the IMLA letter.
Oh, the date of the IMLA letter. Well, that inevitably would have come before there could be any commitment.
Yes.
And I'm not going to tell you that there's clear factual evidence about who was thought to be in the market. You'll see if you go through the documents that there was some confidence that they would be able to find syndicate lending, but there was no, as you'll recall, they actually came up short in the end.
Yes, just wondering whether there were identified principals for the purposes of the agency argument at the time of the IMLA letter, persons who are said to be principals.
I don't want to mislead you, so I don't want to say that there's comprehensive evidence on that. I don't think that that's something that I would rest on. I think that there may have been some banks in the background. There may not have been.
Normally, you've got to be agent for someone.
Of course,
Yeah.
I understand that. And yeah, and I mean, I think though that's the point. That's part of the point of all of this. If I'm appointed for a body, a group of people, then I can make representations for that body. But if they are not a coherent body, there's no role for me to fulfill other than bilaterally with each of those individual banks. And so that's part of the problem of saying that because the NUR took this role, somehow that leads to an agency relationship. In fact, the role that they were undertaking, as a matter of logic, could not have been for an identified body, because there was no body to operate for. So then you have to get into, ultimately this boils down to the case that there might be allegations down the line of express authority being conferred by the individual banks.
Mm.
But the passage that I was showing you, just to deal with the actual criticism that's made of the judgment, the criticism is in relation to paragraph 19, but you have to put it in context, and it starts at B13 and paragraph 18. So this is just to make good my point that the judge wasn't saying, well, at the meeting, that NUR must have been acting as agent for the group. He was saying at the meeting, the effect of the IMLA letter could not have been that the Noor Bank was acting as agent for a syndicate. The relevant parts, I won't read them out for the purposes of time, but it's paragraph 18 and paragraph 19. And you can see it, though, when the judge says, in terms, there's no logical basis on which that letter, that's the IMLA letter, could amount to the appointment by the other claimants of Noor as its agent. So this is all about the case that was being put. There was no logical inconsistency. There was no leap of logic. There was no question of the judge making a finding of fact that was inconsistent with the agreed facts, because the judge wasn't saying that Noor was necessarily acting as the defendant's agent at the meeting in December 2018. That there is someone, I think, on the line who hasn't muted. I think it might be Mr. Fraser, but I don't want to accuse anyone. It's not one of the judges.
It's not me.
Ah, I thought I could saw some background noise. Sorry. Anyway, it's gone now. All right. So that's the sort of discrete complaint that was made about the judge's judgment on this. In the written argument, my learned friend made another point about Noor Bank.
Just before you go on,
yes,
just coming back to the point I made, at 9.1 of the IMLA letter at paragraph 17, the book runner shall manage, including the selection of potential financiers. So plainly that hadn't been settled. What it was engaged in was syndication and the selection of potential financiers. Is that right?
Yes, I think it's right to say clearly the identification of the financiers had not been settled. I thought your question was, were there discussions in the background? One would expect in a syndication that there would be some testing of the market, and Noor would be in conversations who's interested, who's not.
Potential financiers at that stage.
Potential financiers, yes. And obviously some of these banks were already had loans, bilateral loans, extended to the group that needed to be consolidated into the restructuring. And so there clearly would have been some discussions. My point is, I don't want to go too far and tell you that it was not known that any of these parties had any interest, but clearly there were no commitments yet at the time of the IMLA letter. Because at the time of the IMLA letter, that's the very start of the syndication process, where the parties put together the first step is they're appointed as the arranging bank. The next step is to settle the term sheets between the banks, and then the third step is to take it out to market. At which point, after that, you get commitment, and then after that, you get contracts.
Yeah, I'm taking it back to paragraph 55, where the plea is agency for the other claimants. So there's an identified set of principles according to the pleading, but that doesn't.
Implicit in that, there has to be. I agree with that. I'm not sure the pleading ever says that in terms, but I agree that it's implicit that there has to be an identified set of principles. I think that they would say, well, as at the date of the December meeting, when at that stage we do have at least interest, and in some respects letters of commitment, but no contractual relationship. No contracts in place. So I was going to move on just touching very briefly on a further point that's raised in the written case. There is an argument about the fact that it was anticipated that Noor Bank would be appointed as the as the security agent under the terms of the facility agreements. Now that wasn't argued orally, and I'll deal with it shortly. We deal with it in our written argument, but the short point is, firstly, there's no suggestion that they were security agent at the time of the meeting. Secondly, they never became security agent. It was anticipated that they would. And thirdly, that the role of a security agent would not be for negotiating the participation of anyone in the syndicate. It's about managing the security. That is the three short points in relation to that. And really where this comes up to then is this allegation that, well, something might come up at trial. There might be some documents in particular that might come out at trial that would support the case. And my learned friend points to passages in EZS saying, well, where there's a reasonable expectation that you might have further documentation at trial, then that can be a reason to put everything off until trial. But you need that reasonable expectation. And before that, you need a case. You need an allegation that those documents might support. So essentially, this comes down to saying, well, some of these documents might support a case of express actual authority, that there might be somewhere in those documents indications that the banks actually gave authority to do these things, and you might want to investigate it. But that's not the role of a court. The role of a court is to look at allegations that are actually made and determine whether they are accurate and what their legal consequences are. The only document that actually is identified as being potentially relevant is one that's referred to in the appeal skeleton. And they say Noor Bank took legal advice on the terms of the security sharing provisions in the facility documents. And they say, well, when Noor Bank took that advice, it might support the conclusion that Noor was obtaining this security, the OBN security, for the benefit of the whole of the syndicate. Why? Because they say, well, there are provisions in the finance documents which say, well, if Noor Bank makes any recovery in relation to the loans that it advances, it has to share that with the syndicate. So if it gets more security, then that might benefit the whole of the syndicate indirectly. But that swings the case around to being a case that the OBN security was being obtained on behalf of the whole of the security. And I explained to you yesterday why that's inconsistent with the defendant's case. It's inconsistent, or at least Mr. Al-Maheri's evidence on this is inconsistent, but it's also inconsistent with logic, because there's no problem with the syndicate demanding additional security. That's what happens in negotiations. The problem that's asserted in relation to the demand for security is that it was accompanied by a threat not to do something that Noor was, it is said, contractually obliged to do, which is lend. So it doesn't work. And it would only go to the OBN security issue, which I'll come on, and we'll look at that because that turns on the interpretation of the IMLA letter itself. It wouldn't, this issue, this document is not, there's no way to see why it would make any difference to the working capital promise that's alleged. So the reality is there's actually no case explaining how Noor could have been acting as agent for the other banks in demanding extra security for itself or in promising additional lending from itself. And just to remind your lordships, to put this in context, if my learned friend loses on this agency issue, then he cannot make out his case for rescission of the contracts at all, even against Noor, because that would affect the rights of innocent parties. The other banks would be innocent in this. So unless they can somehow be implicated in these promises and these threats, then the financing arrangements stand, and then Noor is left with a counterclaim, but that counterclaim cannot be set off, so that even as against Noor, there's no defence to the claim, there's just a freestanding counterclaim. All right, that is all I was going to say on agency, unless there are any other questions in relation to that. And I was going to then deal quite briefly with the affirmation issue. So just to remind how this arises, the defendant's case is that they had rescinded the facility for duress and for misrepresentation. Now, the issue of affirmation cuts across both of those defences. Duress arises out of the demand for OBN security. Misrepresentation arises out of this alleged promise about working capital, but affirmation would do for both of these. Now, in the pleadings, the defendants also alleged that the promise that they say was given became a term of the facility agreement somehow, that it was an implied term or something of that nature. That went away with the first instance decision and hasn't been renewed. So this is no longer a case about whether or not they can terminate for breach of a contractual promise. This is all about duress, and it's about misrepresentation. Now, there was never any plea about when or how the defendants actually rescinded the contract. The only thing that was alleged was that it came at some point before the 3rd of February 2020. That was significant because that's when there was acceleration. I'll show you that very briefly in the defence at page C57. Sorry, I think it's C58. Should we start at C57? That's right. It's a long paragraph, starts at paragraph 128. But it's just at the bottom of that. The last line of the page C57, and you see it says, if you got there, the defendants have accepted the claimant's repudiatory breach, as I say, that as we see it goes, thereby terminating the OBN syndicate finance package agreement and the syndicate facility agreements prior to the notice of demand dated 3rd February 2020, paragraph 129. When the defendants discovered the true facts, they rescinded the OBN security finance package agreement and the syndicate facility agreements. So and the way that it emerged below in the skeleton argument was that the rescission and the termination occurred, I assume, in the same way, and all before the 3rd of February 2020. And a lot of it came to be about a meeting that took place in December 2019. But that's the case. And what we said was that even if they had a right to rescind, they would have affirmed the facility long before they purported to terminate. And if they had affirmed, then they lose the right to terminate. And then regardless of agency, they're still back in a position where all they have is a counterclaim. So if the defendants fail on the agency ground, affirmation is completely moot. There's no need to worry about this particular ground. But this arises if I'm wrong on agency. Now, the promise that is alleged is working capital would be provided immediately, but by March 2019 at the latest. And what the judge found, I'll show you this very briefly. I'll take you to B17, please. And it's paragraph 34 and 35 of the judgment, where he says the defendants knew that no working capital was going to be forthcoming by the 27th of March 2019. That's paragraph 34. Paragraph 35, and he recites a particular letter, and we will look at that letter in due course, which is the letter of the 27th of March 2019. But you'll see in that letter that it's quite significant, in particular the second paragraph. As discussed, while closing the syndication, we made a technical mistake by assigning all of our projects to syndicate instead of the agreed 70% of the project, only 3 projects remaining outside syndication. On top of that, we overlooked the working capital requirements of the project that are assigned to the syndicate. So that's the defendants writing to the banks saying we basically assigned all of our assets to the syndicated loans, and we overlooked the need to have assets left to get working capital. But the judge found that after this time, the defendants had taken several steps which amounted to affirmation, and he sets some of them out, paragraphs 34, 35, and then at 36, he makes the point that after this time, the borrower went on to draw down twice from the facilities and made repayments of money that had been coming out under the facilities. That happened in April 2019, and then again in July 2019. And that in particular was in relation to the Murabha lending, because the Murabha lending has to be structured as a series of individual contracts. And so the first contract runs till April, and then it's repaid by a drawdown and repayment. And then there's another drawdown and repayment in July. with the payments of interest along the way, or profit, sorry, along the way. What the judge found was that those acts were affirmative acts. And there's no challenge, as I understand it, to that, in the sense that it is not said that if you have the requisite knowledge, that there's an argument that drawing down and repaying and paying interest and so forth is not an affirmative act. What my learned friend says is that the contract wasn't affirmed because the defendants were unaware of their right to rescind. Now, that's the basis for this defense. When we paid in July, when we paid in April, we didn't know that we were entitled to rescind, and presumably by implication we only found that out later. Now, in addressing this issue, my learned friend took you to some authorities that say that this is a factual issue, and of course questions of affirmation will very often turn on factual arguments. But you as a court are still entitled to look critically at what is being alleged. And so you were taken, for example, to the Ukraine case, where it was said it was unsuitable for the court to decide that on a summary basis because it would have to wade through, as it was put, acts and reservations. And in his submissions, my learned friend was, I would suggest, very loose in the way that he presented this. Because what he told you was that in this case, there are issues of fact, firstly, as to whether or not the defendants made a reservation, and secondly, whether their acts of affirmation were procured by promises. So he said that there's factual issues about that. There aren't. It has never been alleged that there were reservations. It has never been alleged we did not terminate, we did not rescind because we were made further promises or because we were induced into doing that. And actually, if one thinks about it, that would be inconsistent with the way he puts his case. Because what he says is that the defendants did not know that they were entitled to terminate at all. And we'll see where that comes from in a moment. But if that is accurate, how can he possibly be saying that they didn't know that they were entitled to terminate, but also they reserved their right to terminate, but also they were induced not to terminate by something else that was said? It's just factually inconsistent. So what this actually came down to was a question of whether or not the defendants had the legal knowledge that they needed. And the only evidence on that came from Mr. Al-Maheri himself. And I'll just show you what was relied on. You haven't been shown it yet. It's in bundle D. Behind tab 6 is Mr. Al-Maheri's witness statement. And you'll see it paragraph 4 on page 1174.
What's the page number again?
1174.
Hello?
I'm sorry, my lord, can you hear me?
Any alphabet before that?
It's
Yeah.
D.
Alphabet,
sorry,
the alphabet before that?
D
Okay.
1174.
1. Okay.
And so this is the sum of the evidence on this that was relied on. Mr. Al-Maheri said, it's the second sentence, really. I'm not familiar with legal concepts such as how rescission for duress or misrepresentation operate under English law. That was it. And as a response to this affirmation issue, the judge rejected it. And I'll show you what he said about it very shortly. But bundle B19, and it's paragraph 41. The defendants contended that these events did not amount to any affirmation because there is a need for an electing party to know of his legal right to choose between the alternatives open to him. At paragraph 4 of the chairman's witness statement, he says that he is not familiar with legal concepts such as how rescission for duress or misrepresentation operate under English law. What he does not say, however, is that he was unaware of any right to rescind or terminate, on the ground of duress, misrepresentation, or breach of contract, as opposed to how the concepts operated. Moreover, it's the knowledge of the defendants which counts, not that of the chairman as such. The idea that there was ignorance in the group of any right to rescind or terminate on the alleged ground of complaint is, to my mind, fanciful, particularly given the ability to take legal advice in the presence of a general counsel. And he goes on after that. So the judge had two reasons for suggesting that this evidence just doesn't get over the hurdle. The first was that the chairman's evidence was narrowly drafted. It was just about his understanding of legal concepts. And the second, and he didn't actually say that he himself was unaware of the right to rescind, only that he was unfamiliar with the concepts, and that was not good enough. Now, and then the second was that it was his knowledge that he was giving evidence about, not the defendants. Now, I'm sorry, you're on mute, my lord.
Yeah, it's okay. Thank you. What's the legal principle governing the failure to elect on where there is an absence of awareness of the legal right to elect?
Yeah, so you need to have a knowledge. You need to have a knowledge that you are entitled. You're entitled to elect.
So the judge is operating on that premise. He just says that it's unbelievable that the corporate group, as it were, didn't or couldn't have that knowledge attributed to it. It'd have to be attributed to it, wouldn't it? On the assumption.
Well, there's two problems that he identifies. So that, yes, that is the second problem. He's saying, well, if you look at the group, you'd have to say that the evidence of Mr. Al-Mahari is about the evidence of the group. And the second point is he's saying, well, actually, if you look at what Mr. Al-Mahari is saying, he doesn't say, I didn't know I was entitled to rescind. He says, I don't know the details of the concepts of English law. Yeah. Now, my own friend says, well, that's too narrow. You shouldn't read it in that way. But it is accurate, actually. And not only that, it is logically the only way you can read it. Because if you look at the evidence that he's giving it in the present tense in 2021. He's saying, I do not have knowledge of these principles. And yet the case...
The attributed knowledge of the defendants, isn't it? Isn't that the judge's finding seems to be at the end of 41, that it's inherently implausible that they didn't have the necessary attributed, of course, state of mind, because and makes assumptions about general counsel and so forth. I think
that's true, but that's his second reason. He doesn't just put it on that basis. He's looking actually at the content of the assertion. If you look at the first part of paragraph 41, in the middle of about 4 lines down on page 19, he says, what he does not say, however, is that he was unaware of any right to rescind or terminate on the ground of duress. Right. But just to package this up and see how this logically cannot work from the defendant's perspective, as I showed you, by the evidence is in the present tense in April 2021. He's saying, I do not have this knowledge, whatever that knowledge may be. By then, the defendants have said they exercise their right to rescind. So, and they say they exercise their right to rescind long before that. They say before February 2020. So they have the requisite knowledge to rescind on their own case before 2020. He's giving evidence in April 2021 saying, I do not have X knowledge. He cannot logically be saying that the effect of that is that the bank didn't, or that, sorry, the borrowers did not have the knowledge that they needed. The effect of that evidence logically just cannot do that work.
I personally, speaking for myself, I have a bit more difficulty with that. A grammatical construction of the average witness statement is not normally very productive. And the incentive you then giving is for the lawyers to spend even longer than they already unjustifiably do, drafting the witness statement in legalese instead of anything resembling the evidence. Speaking for myself with that introduction, I understand your 2 points. That one, I'm not expressing a view, but the 2 points you make are, one, he says, I don't know anything about the concepts, but he doesn't say, I don't know about, I was unaware of the right to rescind. Secondly, you say, though Mr. Fraser contests it, that the important point is not his knowledge, but the defendant's knowledge, and hence the judge's point comes into play about straining credibility. Mr. Fraser counters that last point by saying, well, the chairman is himself a defendant, so it's not irrelevant as to what his own knowledge was. But the present tense point fills me with unease.
But it's not him, does it though? Because I mean, I hear what you say about parsing witness evidence.
Well, they're bad enough as they are, witness statements.
No, I understand, and I'm not asking you to sort of read it as a statute, of course, but he is saying in his evidence, I do not have requisite knowledge. Now, it doesn't come at the point of saying later in the statement where he's explaining what happened. It comes right at the outset saying, I'm not a lawyer. So the question is, what work is that paragraph doing? And what work is it doing? Is it saying, I did not at the time, and the group did not at the time have the requisite knowledge it needed to terminate the contract? My point is, it can't be saying that, because they've already alleged that they have terminated.
You have this principle of your ignorance of the law is no defense. I mean, he cannot say, I do not know the law. Put the blame on the lawyers for not giving him the advice. But apart from that, I would associate very much from what Mr. Justice Cross has just said earlier on. I cannot express as well as he did, but I associate myself with what he did.
Yeah.
So I don't think you should spend too much time on this. Perhaps you may wish to go on to the next. We understand what you mean.
I was answering a question. I mean, it's usually discussed. I mean, I've got plenty of time, but I do want to try and get my point across, which is that all of the cases loaded onto paragraph 4 of that witness statement. What it cannot mean is that the bank did not have, it doesn't say prior to that date or before July 2019, when they made that repayment, we didn't know that we were entitled to rescind. It just doesn't say that. So the whole case is loaded onto that paragraph. And then you have the other point, which the judge was relying on. It's not so much about it strains credibility. It's that there's an evidential gap in the state of knowledge of the defendant group. So on their case, they've been promised 100 million dirham at least in working capital by March 2019 at the latest. And when it doesn't come, they know that on their case, the promise has not been honoured. And on their case, it's causing them huge difficulties. And they have a group general counsel who was dealing with the banks. There's evidence about that. And in fact, Ms. Hanlon was on the call yesterday on this very hearing. So they still have the same individual around. But the fact that they have a group general counsel is significant. It can give rise to an evidential presumption. And if you have to ask yourselves, what would be the position at trial on this evidence, on the state of this evidence? If he gives the evidence, I do not know the concepts, but yes, we terminated before 2020. Is there a real prospect of the defendants establishing that they just did not have the requisite knowledge in July? There isn't any evidence about it. There isn't any, and it does strain credulity. There's particular complaint about paragraph 42 of the judgment, which is page B20. And again, I'm not going to read it out to you, but what the judge was saying was that the willingness of the syndicate to provide further working capital was always dependent on the chairman providing further equity. This complaint that there was some sort of stringing along is somehow said to support the position that there wasn't aberration, despite these repayments in July. Now, in this context, the judge relied on the minutes of a meeting on the 14th of May 2019. Those are minutes that were prepared by the defendants themselves of that meeting. And I want to show you them briefly, if I may. They're in bundle D, D1027. And they're relatively short, and I'm afraid they're sideways. And the relevant paragraphs are page D1028. You'll see this is May 2019. And you see paragraph 3, AFM Group, that's the defendants, requested for following working capital facilities. So they're making a request for working capital facilities. Paragraph 4, Norbank has stressed on the need of equity infusion and the removal of downgrades, and expressed concern on the completion of notices of assignment. Paragraph 6, all banks unanimously agreed to provide approval for an aggregate 150 million working capital limits by May 31st, 2019. However, limits will be released for utilisation. Equity infusion of 25 million is routed through the account bank, and funds will be used for the removal of downgrades. So that's why the judge was saying that the provision of working capital was conditional on an infusion of equity. Those are the defendant's own minutes of the state of the discussions in May 2019. So I think the judge's point at this stage is, well, they know, at this time, the defendants know that there's no working capital coming before March, because, well, by March latest, because we're in May. They know that it's contingent on equity, which is never produced. They're being told that in terms, and then in July, they draw down and repay, and they renew the Marapa after that. And if you go to the evidence and the assertions that are relied on, sort of inducement case, you find that at bundle D still, page 1184, D1184. And it's paragraphs 51 really to 53, where Mr. Al-Maheri firstly describes a meeting in March, which he wasn't at, but Miss Hanlon was. This is the third sentence, third line down. For example, Gail Hanlon, the BBIH Group's then General Counsel, has told me of a meeting that occurred in March 2019, the day before the first instalment, and says, oh, well, there were promises that were made then. And then in paragraph 52, there's a sort of vague allegation about things that were happening in September in Guildford. And then paragraph 53, it all came to a head in December. So you're told by my learned friend that there are factual disputes to be had about reservations and whether or not the defendants held off from terminating or rescinding because they were being made further promises. But none of that evidence actually goes to the question of, well, they knew in May that working capital was conditional, and then they drew down and repaid in July. And nowhere does Mr. Al-Maheri say anything about reservations, or indeed that he held back on rescission because he was being made promises. And he couldn't say that for the reasons that I said, because it would be inconsistent with the case, that they didn't know they were entitled to do that. That was all I was going to say on affirmation. I was going to then move on and deal with duress. Now, so duress arises out of this demand for OBN security, my own friend suggested that we changed our case on that. We haven't changed our case on that. It's about how things are characterized. We accept that in order to participate in the syndicate, Noor required working capital. Sorry, Noor required OBN security. But exactly how that came about is not relevant for the purposes of today. So there's no relevant dispute in relation to this, but there's no change of case either. Now, in order to get started on duress, the defendants accept that they need a threat of an unlawful act. So one has to identify what is the unlawful act. The act was not participating in the syndicate. That's what was being threatened. So they have to show that that was unlawful. And therefore they have to show, and this is what it all comes down to, that Noor was legally obliged to participate in the syndicate. Now, the only place that they say they can find that is in the IMLA letter itself, which is at bundle D, page 186. And this is a short point of construction. It's an issue of law, English law, because it's an English law contract. And what it says, and the question for you is, does this letter require Noor Bank to lend money? The first paragraph that's relied on isn't quite in the terms that was explained. It says, we, Noor Bank, appointed under the terms of this letter as the initial mandated lead arranger and book runner, are pleased to set out in this letter the terms and conditions on which we are willing to use our best efforts to arrange and manage primary syndication. So the opening phrase expressly contemplates that the duty of best efforts is going to be qualified, because it says we are pleased to set out in this letter the terms and conditions on which we're willing to use best efforts. And the very first qualification is totally unsurprising in a letter of this sort. Nothing in this letter constitutes a commitment by the IMLA to provide any financing. There are no further facts which could shed light on the meaning of that letter. None have been identified. But in any event, the meaning of it is just plain and consistent with common sense. Because if you think about the defendant's case, their case is effectively has to be that Noor is underwriting the entire syndication process by this letter, using the words best efforts. Because if on their case, on the defendant's case, if Noor went into the market but couldn't find any participants, then it would be obliged to put up all the money. That's totally uncommercial. It's committing itself to $1.75 billion of dirhams of restructuring loans by these words. Not only is that uncommercial, it discourages the syndication, because the banks who are in a distressed debt situation are considering whether they're going to restructure. And if they know actually they're going to get all their money back from Noor, it disincentivizes them from actually participating in the syndicate. I didn't say it's impossible for an arranging bank to underwrite a syndication in that way, but you would need clear words. And in this case, we have clear words to the contrary. So it's totally unexceptionable. In their appeal, the defendants make 4 points on this. The first is they say, oh, well, the question of best endeavours and whether it's been breached is fact sensitive, and that requires a trial. It doesn't. This is a pure point of law. We're talking about the obligation, not the facts that follow. We know that we know the facts. The question is what the obligation is, and as I say, there's no facts which have been identified which could exist. The second point is that the judge's construction is just wrong, and they offer their own construction in their skeleton argument. And I'll just show you that for a moment, if I may. It's at A29. A29. Paragraph 69. Second sentence, at the end of the first line, properly construed, the purpose of the second paragraph of the IMLA letter is not to constrain the duty of best efforts in the first paragraph. Rather, its purpose is to make explicit that the letter is not in itself a commitment to lend. But that's the claimant's case. Their case is that in the letter, there is an obligation to lend, and they're accepting that the letter itself is not an obligation to lend. It's a curious passage in my learned friend Skeleton Argument, but it I think demonstrates that it's very hard to read that sentence in any way other than that there's no obligation to lend. The third point that they make in written argument is that the construction can't be right because it would give Noor Bank carte blanche to hold the syndication hostage. But all that they're saying there is that if someone's got something you need and you can't get it from anywhere else, then that person is in a strong bargaining position. And then the fourth point that was made is that the defendants say, well, Noor Bank wasn't just refusing to lend simpliciter, that it was refusing to lend and making a demand. But that's irrelevant, because the issue is whether or not the threat was illegal, and therefore whether or not there was an obligation to lend. If there was no obligation to lend, then Noor can make whatever demands it likes in exchange for lending. So without an unlawful act, this goes nowhere. And the counterclaim to rescind for duress and the counterclaim for damages for the tort of intimidation must fail. But there's a second point. I won't spend too much time on it. But the second point is that even if there was duress, what would it affect? It would only affect the thing that was induced by duress, the OBN security. And so even if they made out their case in duress, the lending agreements would remain in place. Now, you only need to consider this argument if you're against me on agency, affirmation, and whether there was an unlawful act. Unless all of those things go with the defendants, it's moot. Because if there's agency, there's no rescission anyway. If there's affirmation, there's no rescission. If there's no unlawful act, there's no rescission on this ground. And so on this, though, the judge said, well, even if you can make out those three things, if you get to a position where there's been duress, what has been induced by duress? The defendants on their own case always intended to enter into the facility. The issue was that they didn't want to have to give up the additional OBN security. And so if pressure was being applied, it was directed to getting the OBN security. It's not causally operative on obtaining the facility. So because, and in this, the judge is capturing something that we say is logically incoherent in this duress case. Because in order to set aside the facility, they have to say that they entered into the facility as a result of the threat. But the threat was that they wouldn't enter into the facility. And logically, you can't be pressured into agreeing a contract by someone threatening not to agree the contract. It's incoherent. The true substance of the complaint is that they were forced to give up the OBN security as a result of the threat not to commit to the facility. So this could only be directed at the OBN security. It couldn't go to the rescission of the facility. And we say that was all illustrated in the pleadings of the defendants, because when it comes to the quantum, their case is at paragraph 131 of the defence and counterclaim, which you find at C58. So when they're talking about counter restitution and so on, in the middle of that paragraph, about 5 lines down, C58, paragraph 131, they say, but for the matters complained of in the defence and counterclaim, the defendants would not have entered into the OBN Security Finance Package Agreement and the Syndicate Facility Agreements, but into a Syndicate Facility Agreement on similar terms to the Syndicate Facility Agreements, without the obligation to procure that security be provided in relation to OBN Energy, with the consequence that the defendants would have had available to it OBN Energy to raise sufficient working capital to meet their working capital requirements. So as a case in duress, it could only be directed at getting the OBN security and rescission of that agreement. It couldn't go to rescind the facilities. because they're saying in terms, if you hadn't made the threat, we would have entered into the facilities. I was going to leave duress there and move on to deal with misrepresentation. So this is ground 4. It concerns the allegation that Noor Bank said at the Palm meeting, and the words are that it would provide a minimum of 100 million dirhams in working capital immediately and by March 2019 at the latest. That's the defence and counterclaim which we're in. It's page 38, C38, paragraph 61. So it's really the last 2 lines on that page. The 8th claimant's representatives guaranteed that they would arrange for a minimum of 100 million dirhams working capital to be provided to the BBIH group by the 8th claimant itself immediately and latest by March 2019. Now, of course, Noor Bank denies making that statement, and I'll come on to that in ground 6. But for the moment, we assume that that statement was made. And the defendants say, well, that gave rise to a misrepresentation. And of course, on its face, what they're alleging is that Noor Bank made a promise. And the problem with the misrepresentation case is you have to find the implied representation. And your lordships are absolutely right. What this boils down to is an allegation that there was an implied statement of the intention of the group, sorry, the intention of Noor Bank, and that intention was false. And that is an allegation of dishonesty. Now, they've disavowed that case belatedly because they did rather raise it below in certain ways. But what they say in response to your questioning and in response to the questioning below and in their written case is that the promise contained, and I quote, an implied representation that there were reasonable grounds for Noor Bank to make the promise. And you have to unpack that. And as I say, that resolves into an allegation that there was an implied representation that Noor Bank intended to make it. Why do I say that? Because ultimately we've produced the passage in Chitty that deals with this. We don't have to go to it. You've got the reference in the skeletons, and we'll talk it through. That there are 3 types basically of implied statement of facts that you might be able to get out of a promise in the right circumstances. So we don't concede that there were these implied statements, but this is logically where the case could go. Firstly, a representation that the maker has a present intention to do what he's promising. So that's the first potential implied representation. Second, that the maker has the ability, that there are reasonable grounds to say that the maker has the ability to do what he says he promises to do. And sometimes that's put the other way, that there's a representation that the maker is not aware of any facts that'll make it impossible to do what they say they'll do. And then the third is it can contain a representation about what a third party intends to do. Now, in our case, the second and the third don't arise. So this is really about Noor's intentions. So the complaint is that the evidence shows that Noor Bank's credit committee had firmly taken the view that there was to be no more lending above the level of exposure under the syndicate. Now, you'll recall that there's a bridging loan of 500 million, and there's all these documentation internally. I won't take you to them now. I will show you them in a little bit, just when I'm dealing with the factual issues. But there's clearly a commitment and a requirement to reduce that exposure from 500 million. And so the complaint is really an allegation of dishonesty. They are saying they promised to do something which carried an implied representation that they intended to do something which they knew full well they did not intend to do. That is how it was put below in written argument by my learned friend, and it was also how it was put in evidence by the chairman. And I'll just show you that briefly. Let's just go to the chairman's evidence, or Mr. Mahari's evidence, which is bundle D, 1182, paragraph 44. And it's the last 4 lines, he says, while I was not happy with the way Noor Bank had managed the syndication at the time, I thought at the very least that they were ethical people who did not lie. It now turns out that what they were saying was not true. Mr. Ali claims that they were not entitled to guarantee me the money, despite their promises. So the allegation, and it was said to shade into dishonesty below in my learned friend's skeleton argument, but that case is not open to the defendants to allege. It's not renewed on this appeal, and in reality, it should never have been put in those terms. Now, what my learned friend does is he tries to get around this problem by saying that the issue is about whether Noor's representatives at the meeting had reasonable grounds for making the statement that Noor would lend, given the position of the credit committee, and so there's room for negligence. And this was the argument that my Lord Speaker Gross picked up on, which is that there has to be a supposition that one part of the bank doesn't know what the other part of the bank was doing. But we know the position, we have it in the documents. We can see that everyone at the meeting was fully aware of the credit committee's decision. So I'll just show you that very briefly. It's page D577. Is where we start. So this is a report, D577 is a report dated 10th of December. Or it might be, actually, I might have got that wrong. I'm not sure. That might be 12th of October. I'll need to check that. In any event, this is a report you can see at the top left from Corporate Banking Dubai to Credit Risk Department. I thought it was 10th of December, but it might be 12th of October. It doesn't matter actually for these purposes. And you'll see at the bottom, the last full paragraph on the page, Noor is entering the syndicate with its exposure at 500 million. We are targeting to reduce our hold to 250 million after the closure of the syndicate. And then goes on to deal with so it's quite clear that the people who wrote this report knew exactly what the intentions of the bank were. And if you look on page 580, you see who wrote the report. It's Mr. Ali, Mr. Khan, Mr. Naqvi, and Mr. Sheikh, all of whom were the people at the meeting. If you need evidence for that, it's accepted, it's agreed that Mr. Ali was at the meeting. I think the chairman's evidence is he doesn't know who else was at the meeting, but the evidence from Mr. Ali is at D53, paragraph 60. But in any event, Mr. Ali is on that. And then page 581, if we go down in the bundle, this is from the 13th of December. That's definitely the 13th of December. It can't be the 12th of the 13th. Mr. Mohammed Naqvi, and it's from Mr. Shafi, and you'll see copied to Adnan Khan, Faisal Sheikh, and Kazim Ali. So all the people at the meeting. And then under the list of confirmed commitments, the total amount raised from existing banks is 1250 million, excluding Noor Bank. Noor's commitment under the bridge is 500 million, so the total amounts to 1750. As per internal approvals, Noor has to achieve a final hold of 250 million in the syndication, for which we are discussing with a few potential banks and anticipate this to be achieved by mid-April. And then the final one is at 598, and this comes on the day of the meeting. Okay, D598, you see from Umar Gufran, 16th of December 2018, 2:29 p.m. It's sent to Mr. Naqvi, Mr. Ali, you'll see Mr. Sheikh and Mr. Khan. So BECC approval, Bank's Executive Credit Committee approval, was on the basis that 1, we will reduce the bridge from 500 to 250 million in the syndication, and 2, in case the syndication is not successful, we will continue with the bridge of 500 million, which will then be converted into a bilateral. While one of the board members had expressed reservations about a successful syndication, we provided reasons why we felt that the syndication will be successful. Now the situation is, while the syndication is taking place, we will not be able to raise enough to reduce ourselves to 250 million for the reasons in the attached memo. In the discussion last week, syndication team had assured us of reducing the exposure via an upsized secondary by April 14, must have been April 19, considering, April 14th, sorry, considering people will be back from holidays around mid-January. I'm okay based on this assurance, and I'm requesting MCC to Management Credit Committee to concur. We can notify the BECC in the next meeting in end January. So the idea that the people in the meeting were simply unaware that the bank had a settled intention to reduce its exposure is simply demonstrably wrong. It is fraud or bust on this misrep, and it's not fraud, so it's bust. And that is even if you can get to a case on implied representations of fact by carving up Noor into, in effect, two distinct entities, one of whom knows something and the other whom doesn't. But there's another point on this, which is that the judge had a second basis for dismissing the case on misrepresentation, because he said even if there had been an implied representation, it was not one on which the defendants could reasonably rely. That's paragraph 53 of his judgment, page B25. And the problem he found was that there was a lack of any specificity in the alleged promise. So for the same reason that it was too uncertain to be a promise, whatever representations there may have been in the statement, it was too uncertain a statement to be one that could be reasonably relied upon. And effectively, he's saying if a bank goes in and says, I will get you, I will give you working capital of 100 million, that's not a promise that you can reasonably rely on. It's not a statement of intention that you can reasonably rely on, because it's too uncertain. It's too uncertain to amount to a contract. It's too uncertain to be something that you can put your business affairs and arrange them around. Now, the defendants don't address that. They say they don't need to because the judge was dealing with some other representation, not the one that they had alleged. But it is completely clear that that is what the judge was doing. And he says it, as I say, and I won't take you to it. You can look at it. It's in the judgment, paragraph 53 at B25, and it's in the permission to appeal judgment at paragraph 13 at B41. And there's actually no appeal against that secondary basis at all. That's what I was going to deal with in relation to misrepresentation. I was going to come on and deal with collateral contract. I don't know whether or not you'd like to take the break now or whether we try and get through that section. I'm in your hands.
How long are you going to take on that?
It might be, it's hard to say actually. I'm not sure. It won't be long, but it might be more than 5 minutes. I'm making good progress. I'm about halfway through what I have to say. I don't think we're going to struggle for time.
Yes. Okay, you can finish in 5 minutes. Do so.
All right, I'll try. In relation to ground 5, then, ground 5 is about collateral contract. And so what's being alleged is that this statement,
Mr. Montague-Smith, that was a counter offer.
Yes, I accept. There's a rejection of my original offer, I think, impliedly. So the defendants have alleged that this statement, we will give you 100 million, gave rise to this collateral contract. So they say there's an oral agreement by the bank to lend 100 million dirhams in working capital at some point before March 2019 by making this statement in a meeting. There's no other express terms are alleged. Now, we say, and I'll come on to it, we say that's obviously incredible, but we also say it's uncertain, and it's too uncertain to amount to a contractual promise. And the court has the evidence of the two loans that Noor participated in. The first was the bridging loan that came before the syndication, and you've got that in the bundle, and it's 162 pages long and starts at D200. I won't take you through it. You have the syndicated loan agreements, which themselves are 368 pages long, and in all of that, there are detailed terms governing law and jurisdiction. And this would have to be murabha, because this is Noor Bank lending. So this is the form and structure of the murabha. It's not a straightforward contract. The terms for the profit, which is obviously the Islamic equivalent of interest, the terms for repayment and renewal of the murabha, terms about security, terms about what happens if there are defaults, remedies for the defaults, acceleration, late payment fees. None of that is alleged to have been agreed, at least expressly. And so the judge held that in light of that, an oral statement, we will lend you 100 million in working capital by March 2019 latest, was too uncertain. It was too uncertain to amount to a contractual promise. Now, in his response to this, my learned friend majored on the issue of part performance. He said the judge failed to take into account that if you have part performance, the court will be more likely to find certainty in the terms. But there are two problems with that. The first is we don't accept that there was anything that amounted to part performance. So there's no dispute that Noor did not provide working capital. So there was never any performance of a contract of loan. Now, what the defendants say is that the promise to lend working capital has to be seen as part of a package, and they say it's part of the agreement by the defendants to give security over OBN. But there's no logical connection that makes them into a single contract. They can stand as two separate contracts, and they do. If you look at the defendant's case, I've shown you the relevant paragraphs, but ultimately what they're saying is if it wasn't for all of this, they would have entered into the facility as a result of being they would have entered into the facility anyway. But even if there is some sort of part performance that you can divine in all of this, it doesn't cure the problem of certainty. It might mean the court is more willing to find the terms somewhere, but it doesn't. You still need a mechanism to give content to the terms. I think in this case there isn't one. And what they've come around to is they say, oh well, because the contract was collateral to the facility, it can be inferred that it was on the same terms as the facility. Now, there's no pleading to that effect, but in any case, there's no logical basis for making that leap. There's no assertion that it was expressly agreed. They just say, well, that would be it. They don't say the bridging loan, for example. They say it's got to be under the terms of the facility, but the facility is a multilateral term loan, and it's got to be repaid over a number of years. Working capital on this basis would be some sort of bilateral facility, and working capital is usually a revolving facility. Why would it be a term loan? There's no reason for thinking that the price would be the same. The profit on it would be the same. And there's no allegation or evidence that there was any agreement on any of those factors. Just recalling, this is not an ordinary common law loan. This is an Islamic facility because it's Noor Bank. So the transactions would have to be structured as a series of commodity sales, identifying products which need to be provided in exchange for the finance. And on the defendant's case, there would have to be restrictions as to the use that could be made of this money, because it's an Islamic loan on their case, and therefore has to be used in a Sharia compliant way. And there's a host of other regulatory considerations that would come into play before a bank is going to commit itself to lending money on that scale. And we can see from the facility itself how complex the terms are for these sorts of things. We say that you can't just assume, there's no basis on which to assume that this would somehow allied with the terms of the facility. And if you can't do that, it just doesn't have the sorts of terms that would be required for a loan of this sort. Noor can't have been saying, I will lend you this money on commercial, conventional terms, because they're an Islamic lender. And the other part of it is, well, what about security? That's obviously one of the key issues that you would want to know about if you were lending money. What security is being offered for this working capital? Well, the defendants say, well, the OBN security would have been the security for working capital. But their case on duress is that the OBN security was offered to induce the lending under the syndication. So it's inconsistent with their own case. So if in effect what they have to say is that this is a promise for unsecured lending of 100 million dirhams with no on a loan, presumably. I mean, that's what's asserted in a way that Noor just couldn't do, with no agreement as to when it's due to be repaid and no agreement as to the rate. And then there's the other problem, which is that the allegation is that it's a promise of a minimum of 100 million dirhams. So there's even vagueness as to precisely the scope of the primary obligation. So that's why the judge found that even if those words were said, they would not be words which could give rise to a contract. All right, that is the end of ground 5. From I was 8 minutes rather than 5, so I apologise for that. We got there.
Okay. So we'll take what 10, 15 minutes break. 10 minutes break.
10:30. Is that?
I would request for a shorter break this time and a longer break later. So where can we take 10 minutes now and 20 minutes later? Is that all right?
Perhaps half past the hour. Would that work?
Yeah. Okay. 30. Yeah. Okay. Fine. Thank you very much.
Thank you.
Yes. Yeah, Mr. Motica Smith, please continue.
Thank you. I was going to turn now to deal with ground 6, which is the Palm meeting and what happened at that meeting. Now, my learned friend spent quite a lot of time on this. I'm going to spend less, but not because I agree with him, obviously. But I hope I can show you quite shortly why the judge came to the right conclusion on this. The question is whether or not the words were said at the meeting to the effect that Noor Bank would provide 100 million in working capital immediately and by March 2019 at the latest. So it's about whether the words were said, but that, as I mentioned yesterday, just establishing this ground wouldn't be sufficient to get my learned friend home on anything. He also needs to succeed to make any progress on either ground 4 or ground 5, misrepresentation point, or converting it into a collateral contract. Because if he doesn't succeed on either of those, then the ground is moot, because the words would not be legally significant. So the first thing my learned friend does is he criticizes the judge for conducting a mini trial. Now, it is right that conflicts of evidence are normally matters for trial. However, at this stage in the proceedings, the judge is entitled to look critically at the evidence, and he is not required to take the defendant's witness statement at face value. That is clear. That isn't so. It is not right to suggest, as that ultimately the submissions took you to, that you can never resolve an issue of fact. You can never dismiss an assertion of fact at this stage. It's absolutely not correct. The right approach is the one we summarize it in our skeleton argument. It comes from Easy Air in the Court of Appeal, but it's been adopted in this jurisdiction for good reason. These rules are based word for word on the English rules. And it's been adopted in the David Hay case, but the words are. I'm just going to read them to you rather than take you to them. It may be clear that there is no real substance in factual assertions which are made, particularly if they're contradicted by contemporaneous documents. Contemporary activity or lack of activity may similarly cast doubt on the substance of factual assertions. Now, immediate judgment, I would suggest, is an important tool for the courts. And the purpose of these courts is to hold people to their bargains and within a reasonable time frame. And immediate judgment is an important tool to ensure that the court can carry out that mission. And the rules to that end allow the court to cast a critical eye over factual allegations at this stage. Otherwise, it simply becomes all too easy to push back obligations by years. This was an experienced judge with years of experience in England, with the same rules, 7 years of experience sitting in this court with these rules. He knows the test. He knows how to apply the test, and he also has lengthy experience of how these sorts of things plan out at trial. For example, one of the cases relied on was the Hexagon case, where the Court of Appeal said this needs to go off to trial. And when you look at the judgment, the ultimate judgment in Hexagon, it was all pretty clear. And it took the judge sort of about 8 days to produce a judgment after a 3-week trial. My point is that it's quite a thing to suggest that he approached it wrong. There may be a range of different conclusions about how far you go into the factual analysis, but that is for the discretion of the judge. It's effectively a discretionary approach as to how much they look into it. There, of course, is a line at which point it becomes a mini trial. But it's quite something to say that as a matter of discretion, he went too far. And it is worth in this context recalling that if what it comes down to at trial is a contest between what the chairman, Mr. Al-Maheri, says happened at the meeting on the one hand, and the documentary evidence, the outcome of that contest is going to be clear, because the modern approach to that sort of evidence is that little, if any, reliance is placed on witness evidence by a trial judge as against contemporary documents. And we get that from the case of Guestmin in England. I'll just show you that very briefly. It is just worth having that principle in mind when we go through all of this. It's in bundle F behind tab 14. And the place I'd like you to go, please, is F373. And it's paragraph 22. In light of these considerations, the best approach for a judge to adopt in the trial of a commercial case is, in my view, to place little, if any, reliance on on witnesses' recollections of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary evidence of known or probable facts. This does not mean that oral testimony serves no useful purpose, though its utility is often disproportionate to its length. But its value lies largely, as I see it, in the opportunity which cross-examination affords to subject the documentary record to critical scrutiny and to gauge the personality, motivations and working practices of a witness, rather than in testimony of what the witness recalls of particular conversations and events. Above all, it is important to avoid the fallacy of supposing that because a witness has confidence in his or her recollection and is honest, evidence based on that recollection provides any reliable guide to the truth. And that tangentially addresses to some extent my learned friend's suggestion that you have to find that Mr. Al-Maheri is lying about all of this at this stage, and that's a terribly difficult thing to do at the interim stage. You don't. The question is whether, in the light of all the documents, and we'll go through some of them, in light of the inherent probabilities, it's enough for a party which owes 1.75 billion dirhams and more to just say in a witness statement in a couple of paragraphs, oh, well, I was promised something and it wasn't delivered at a meeting. And there's no recollection, there's no record of it anywhere else. Whether or not that is sufficient to get you to what my own friend describes as being, I think he said, a 6-week trial was the appropriate way, which could well come in a year and a half's time or 2 years down the line. We're already 3 years into these proceedings. But this, what I've just shown you, is the modern approach to evidence. There's much less emphasis placed on the importance of oral evidence in the modern commercial dispute resolution system. And I would urge the court to take that approach and to take a robust approach to these sorts of allegations. Now,
I'd be a little careful for myself in just how far you go with Guestman. That traditionally in commercial cases, the contemporaneous documents are what one looks at.
yes.
Well, there is a danger in reading Guestman a bit too enthusiastically.
Perhaps, and I don't say that oral evidence is irrelevant, and I don't say that it has no value, but the authority is not just Guestman, it's the easier passage that I referred your lordship to, makes clear that if on the one hand, all the documents point in one direction, and then you've got a witness who just says, well, this happened, then you are entitled.
To me, that's a separate point from Guestman.
I see.
You don't need Guessman for that.
All right. Well. I understand. I think that my thank you. I understand. I understand the position you're taking. My suggestion is that there is a nuance that we can get some assistance from Guessman, but I understand your position on that, and I won't press it at this stage. The reality of this issue is that there was the only positive evidence in support of this factual allegation comes from the chairman's witness statement, Mr. Al-Naheri's witness statement. Now, you were taken to lots of documents in my learned friend's submissions at some pace, and you were shown fragments of those documents, and you were told, it was boldly asserted by my learned friend, that those documents supported his case. And in fact, and we'll look at them, but in fact, there's no trace of this statement in any contemporaneous document, none. The documents you were shown do not support my learned friend's case. They're either neutral or in many cases totally inconsistent with what he seeks to establish. And in essence, the judge had 5 problems with Mr. Al-Naheri's account. His concern was, firstly, it was vague. It was not supported by contemporaneous documents. And as Mr. Al-Naheri had conceded, a record of this would be expected. It was internally inconsistent. It was inconsistent with the fact that Mr. Al-Naheri knew that Noor was looking to reduce its exposure, not increase it. And importantly, there was a mass of contemporaneous documents which were inconsistent with it. Now, you I think, have been shown the evidence, but we just go back to it very briefly. The evidence, I mean, Mr. Al-Naheri's evidence, which is at D1182, and it is paragraphs 42 and 43. Just ask you to remind yourselves what it is that supports this whole case.
Sorry, which paragraphs?
42 and 43. Again, I won't read them out if I may, just simply because that will take a longer time. So my suggestion would be that the first criticism, just dealing with them in order, that the judge made of this evidence is correct. It is vague evidence. No individual is identified. There's no further explanation of precisely what was said. And my learned friend says, well, there are reasons for that. And he gives a series of reasons. He says, well, Mr. Al-Naheri's already explained he wasn't heavily involved in the negotiations. He has access to limited documents from which to refresh his memory. This all happened many years ago. Mr. Al-Naheri at the time was focused on other matters. Those were the points that were made by my learned friend to explain why it was vague. But none of that helps support the evidence as a fundamental plank of his case. It just undermines the strength of the evidence. Those are reasons why the evidence is weak, not reasons which could explain or support the case. And it's right, the chairman did say he wasn't involved very much. You see that at paragraphs 8 to 10 of his witness statement. He concedes at paragraph 16, for example, on page 1176, that it's difficult to remember every email and conversation he had because it was all a long time ago. But then he says, oh, but I still remember the key details. So his recollection is poor, but he's asserting that has a very clear recollection. That we know from his evidence that other witnesses that he might want to call, paragraph 18, he says will not testify for the defendants. And we know paragraph 19 that he has no further documents to produce. So it's not going to be improved by documentation or other witnesses being produced. So all of those sorts of arguments, these are the reasons why he's unable to be more specific, actually make it more difficult to found a case on all of this. The second point is the judge said the chairman's evidence was inconsistent, and I've shown you this as well. The chairman says that firstly, he accepted that Noor Bank wanted to reduce its exposure and required additional security itself to participate in the syndicate. That's paragraph 40. And then I pointed out that at paragraph 42, that switches to becoming a demand for the OBN security for the whole of the syndicate. And then at paragraph 45, that switches back to saying that the security was only for Noor Bank. So it is right that his evidence is internally inconsistent about what was being said at this meeting. And then the third and fourth reasons I'll look at together, because the third reason was there was a lack of support from the contemporaneous documents. And we say there is not a single document which records the alleged agreement in writing. The first time you see a written statement that there was this agreement comes in the defence and counterclaim. And the chairman says at paragraph 46, middle of his paragraph, it's common for me in business to make deals over a handshake and enter into agreements in such a manner, although I would then expect my team to subsequently record them in writing. And what the judge said about all of this is that the judge's comments were totally consistent with that expectation. In paragraph 66 of his judgment, which is at B29, but you don't necessarily need to go to it, he said, whatever was agreed at that meeting, it was inevitable that it would be recorded in writing in one way or another in exchanges between Noor and the BBIH group. While high-level in principle deals may be made orally, there's no way in which such an agreement to give a loan and the terms of it would not be put in writing. Without such terms, neither party could have any genuine commitment. It's difficult to that, and that was open to him at this stage of the proceedings. If there had been an oral agreement, everybody accepts it would be anticipated that there would be a written record of it. And then the fourth reason, or the one that I want to deal with, is that there are abundant contemporary documents, we say, inconsistent with the case. Now, so I'm going to go through the documents relatively rapidly, but we are going to have to go back to some of the documents that you were shown yesterday. I'm hopeful that it won't take too much time, but it is an exercise worth doing. My learned friend started way back in September 2018. So, and you'll recall the meeting is in December. And he makes the point that there were indications that there might have been, well, he argues that there might have been side promises by Noor Bank along the way. So that's sort of how he develops the case. He takes you to fragments of documents and says, well, that's consistent with there possibly being side promises along the way. Just to preface this, there's no allegation that there was a side commitment at any time other than in the meeting in December. So it's unclear how that has any connection to the facts of this case. But before the term sheet was concluded, there was discussion, it is right, about whether or not working capital would be included in the syndicate. And so, for example, if we go to bundle D, page 429,
Mr. Montague-Smith, on this exercise, have you got somebody who can take us straight to the documents on screen? Somebody on your team?
I can make that request.
Yeah,
perhaps
that would speed things up a bit, speaking for myself.
I'm grateful. I'm going to ask Matthew, Mr. Watson, to give that a go.
I think so. You know, I think what Mr. Fraser did, or his supporting staff doing, was, you know, link it immediately, so I don't have to type and look for the picture.
I see. All right. I'm going to ask, and I'm afraid I haven't arranged it in advance, but hopefully that will happen. But perhaps we can at least try. Most of the documents that I'm going to ask you to look at for the next 5 minutes are pretty close together. So hopefully, while that is happening or being arranged, and we'll see if it can be arranged.
Ah, good. Something's happening.
I'm getting encouraging signals from my junior, so he's going to try. It's D429. You may have to accept and agree to follow the presentation. It's not happening for me because I'm working from PDFs, I'm afraid. All right, so I'm probably going to be way behind you and take much more time. I'll try and be speedy. So what we're looking at here is a document from September 2018, and it's.
Yeah, I'm sorry to interrupt, but this is Umar from Lloyd Misho. Can we have access to the documents as well, if a reporter can see the document as well, just in case?
Perhaps somebody can try to arrange that online. It's probably not the best thing to try to do halfway through day 2 of the appeal, but there we are. I suspect someone may be able to help you with that.
You can just type page number. Just type page number. Don't worry about don't worry about viewing the document. For your purpose, you just type the page number. When Mr. Montague Smith mentioned the page number, you just type that.
Yes, sir. It is for the reporter.
Yeah, that we understand. Thank you.
Thank you.
I'm sure someone will try and arrange that for you. All right, so we're just going back to September and dealing with the submission that there was discussion about working capital at this stage. So this is before the term sheet is agreed, and you see that there is a reference from Mr. Ijaz coming from the group, an email written to the bank, and it says, please find enclosed amended term sheet for your review. So it's in the context of discussing the term sheet, and he says, as discussed in our meeting, in addition to 300 million working capital lines, we are requiring 200 million bank guarantee limits. Current exposure of bank guarantees is around 120 million. These guarantees are backed by contract assignments, which are mostly long-term. I would suggest to include working capital and guarantee limits, part of syndication deal, because in case these limits will be arranged on bilateral basis, then assignment of already assigned contracts against working capital limits, and as well for the new contracts, would reduce the collections for the syndicate banks and operationally bring a challenge for us, and as well for the syndicate banks to ensure what level of collections are being taken out. So he's requesting there that working capital be included in the syndication. But then if we go down to D451, we see the outcome of all of this. So D451, sorry, is the same email. And then just in response to that above, page D450, dear Misbah, coming back. So this is an email back from the bank, 9th of September 2018, to the group. The discussion we have had earlier was for 1.7 billion syndicate, while understanding that the working capital limits would be continued by existing banks or arranged by you on bilateral basis. Let us know if any further approvals have been reached out to you from your existing banks. So what is happening is that the group says we want working capital to be in the syndicate, and Noor Bank's coming back and saying, but we've already agreed this, and this is in September. We're not going to include working capital in the syndicate. You have to either continue those working capital limits with your existing lenders or arrange them on a bilateral basis. And then we see, actually, it doesn't make it into the term sheet. There's no dispute about that. There's no working capital provision in the term sheet that goes out to market. And then there was some subsequent attempts to slide it back in again. You'll see that, for example, at page D495. At the bottom, there's an email. This is now the 16th of September. The group is providing the enclosed term sheet back, and then there's provision. So attempts to sort of reintroduce things are rejected. So that takes us up to 17th of September. But then, of course, none of this is all ancient history by the time we get to the meeting, because this is about negotiations between the arranging bank, Noor, and the borrower about what's going to go out to market in the syndication. So none of that is relevant. My learned friend then relies on some other documentation that comes in September. He says this is particularly important and takes you to page D554. This is an email of the 30th of September. So 2 weeks after the discussion, we're not going to include it in syndication, working capital in syndication. The request comes back, dear Adnan, kindly also update us regarding working capital facility mechanism. It must, otherwise the whole syndication effort will go useless. And then the answer from Mr. Khan, let's have that sorted tomorrow. So my learned friend places some emphasis on this. And of course, this is coming 3 months before the Palm meeting, before the promise is actually said to have been made. And the judge rejected this as being a document which in any way supported the defendant's case. The emails refer to a working capital facility mechanism. So this is, he said, plainly a reference to the mechanism that is required in any facility to permit the borrower to go off and get working capital. Because part of a facility and a restructuring is a ban on any further borrowing. So there needs to be a carve out for a certain amount of working capital. And there was, it's called permitted financial indebtedness in the common terms agreement. If you want to see it, you can see it at page D833. We don't need to go there for now. You also see it and at clause 20.16 at D879. And the defendants say, well, he shouldn't have reached that conclusion because that's all a matter for trial. Because you can't work out from the document itself what this is all about. But the judge can read what this says. The defendants say they're not going to be able to produce Mr. Ijaz as a witness. There's no witness evidence going to come from the defense which could explain what this conversation is about. It's just about interpreting the documentation. Mr. Al-Mahari doesn't say he can give any evidence about this. He says he's not that close to the transaction. So the evidential position in relation to this document is the same today as it would be in a year or two after a very expensive trial. And the conclusion is right. It gets them, but say that this is something. It's very difficult to understand quite what the point is being made here, because it is not being alleged that there was some agreement in September that Noor would offer working capital. If there was that promise, if that was the thrust of the submission, what's the point of the promise in December? But there just isn't a case that there was some agreement at that stage. So that's the points that come out of these documents in September just don't take my learned friend anywhere. They do not provide any support for what happened at that meeting. What we can get some information from is Noor's internal position as to its intended exposure. We know from the documents that I've shown you, and just so they're in the right place in the transcript, I've shown you them, I won't show you them again. It's D577, D581, D598. We know that Noor's strategy was very fixed on reducing from its current exposure of 500 million dirhams down to 250 million dirhams. So the idea that it was then going to promise another 100 million dirhams in circumstances where it was trying to reduce its exposure is completely inconsistent. Now, those are internal documents, but we make 2 points on that. The first is that it makes it inherently all the less likely that there was this alleged promise. Because what the case then is, and it has to be, is that Noor Bank at the meeting was promising something that it knew it could not deliver. And again, that will resolve itself into an allegation that it was acting fraudulently. And my learned friends now acknowledge that they can't go that far. So that's the first. It's inherently improbable, and they can't go as far as to say there's fraud, but that is what their case amounts to. And then the second point is that Mr. Al-Mahari was aware of this intention. He knew that Noor Bank were fully committed to reducing their exposure. And therefore, this idea that they were just going to promise 100 million dirhams on top of what was already out there is very unlikely. Now, we then have documents which record what happened at the meeting. So if we go to page D593, start there. You'll see in halfway down the page is the email from the 17th of December 2018, the day after the meeting. And it's sent from Mr. Khan, who was at the meeting, to Mr. Vig, who was at the meeting. And the defendants accept that Mr. Vig was at the meeting. They're not sure precisely who was there for the claimants, but they accept that Mr. Vig was there. That's Mr. Al-Mahari's evidence at paragraph 35. For the note, it's D1180. And Mr. Khan says, "Dear Mr. Rishi, as discussed over the meeting yesterday, we'd appreciate your support to have the following support. Number one, creation of mortgage lease assignment over OBN asset in Hamria. Please share with us the article's memorandum of OBN Energy to identify the powers of the manager of OBN and to ascertain who can sign for the same. And then number two is the share pledge, which was another side issue, which you don't need to be concerned with. It never eventuated, but it was another thing that was discussed. We would be having the related documents ready in the next few hours, however, seeking your support as identified above to close these quickly." And then the response comes back, "Dear Adnan, sure, I'll arrange the details. Gulfa can be a condition precedent to the event, 15 million shares at current market value rate. Let's keep the documents ready for OBN. It's important to we focus on signing the borrowing agreement first on the 20th of December. So there's no reference there. Immediately afterwards, there's no reference to this very important promise that is alleged. But it gets clearer because you have documents then that come from the defendant's side about what was agreed at the meeting. So if we go down to page 621, you'll see Mr. Padiyar copy sends to Mr. Khan, Mr. Naqvi, Mr. Sheikh, and Mr. Vig, and also Mr. Mustafa. And Vig, as we know, and in fact we say Mr. Mustafa as well, they were both at the Palm meeting. "Dear Adnan Naqvi," this is quite an important email, this one. "During your meeting with our group CEO and group CFO, we have agreed on the following." So this is a document coming from the defendant's side. "To offer mortgage on our OBN facility in Hamria Free Zone as an additional security to support Norbank existing loan exposure and advanced facility management. Norbank will release the charges on the OBN facility if it is able to sell down its partial exposure by the 31st March 2019. And two, to pledge our shares in Gulfa subject to bringing the fresh equity of 70 million in the business by 31 March 2019. Norbank will release the pledge on shares immediately on satisfaction of the agreed equity infusion. And then Norbank to share the draft side agreements in line with the above for our review. As agreed, we will proceed with above mortgage of assets and pledge of shares to enable facility documents sign off tomorrow." So that is the defendant's record of what was agreed at the meeting. And see on the next page, 622, Norbank, I think this is the internal record, and in Norbank's internally arranging the drafting of the documentation, dealing only with the OBN Energy and the Gulfa share pledge. And then on 626, again, quite an important email, this one, 626, in the middle of the page, or towards the bottom of the page, Mr. Hakim from Norbank emailing the group, Mr. Padiyar and Mr. Vig, amongst others. And he says, "Dear Amit, as discussed just now, please find attached," I think that is, "the record, the letters as per DFM format, which need to be signed by Mr. Hassan and Ms. Amna at the earliest to initiate the share pledge process. These were earlier shared with Shridhar. Kindly arrange to have these signed at your earliest. Additionally, as discussed, we are arranging for the side agreement. Please proceed with completion of all documents simultaneously." So my learned friend said yesterday, on their face, none of these documents purport to be a complete record of what was agreed. But this one does. It says this is the side agreement. All documents need to be signed simultaneously. And then Norbank responds, Dear Ahmed, confirming the following. This is at the top of the page. Gulf for share to be pledged to us and will be released when the equity is injected through Noor. Number 2, OBN asset will be mortgaged to us and will be released when Noor comes down to 250 million hold in the syndicate. This has been our agreement with you and will be incorporated in a side agreement that my lawyer is drafting. Since she's been busy with AFM syndicate documentation, she could not provide this earlier. However, it would be provided this week. So again, this is the agreement with you. So we've got contemporaneous documents saying that is the beginning and end of what was discussed. And then drafts are prepared shortly after the facility closed that make no mention of any working capital. We go down to page 968. You can see what was prepared. So this is the document that was promised as being the side agreement. These are the documents. Starting at 968, 8th of January, this is the proposed draft side agreement, and you'll see there in very similar terms the scope of the agreement is what is written there. And then we have the rival drafts, which come back. You see page 977 now, D977, 14th of January 2019. This comes from the defendants. Dear Adnan, please find attached the draft side letter on OBN mortgage and Gulf for share pledge. Let us know if you have any comments. And then you see those documents at page 979 and 980. 980 is the pledge, but if we look at 979, because my learned friend says there's more significance in this, you'll see that that just deals with the OBN mortgage. So if you follow the correspondence through, what you have is immediately after the meeting, discussion about what was agreed, an attempt to reduce it into writing, and the four corners of that agreement set out in these in the documents that follow. The idea that any of these documents support my learned friend's case is simply fanciful. Now, my learned friend makes a specific point on this document, because you will have recalled that my position and what you see in some of the documents is that Noor intended to reduce its exposure to 250 million and then release the OBN security. Whereas in this document, you see reference to a different number, 350 million. And so what my learned friend places some significance on this. We're in D979. And in the middle of the page, it says Noor agrees to irrevocably and unconditionally release the mortgage as soon as possible after Noor's exposure under the CT agreement of 500 million has been reduced to 350 million, the release. Noor further obligates itself to use best endeavours to reduce the above referenced exposure, but in any event no later than 30th of June. Now that's the defendant's drafting. So in effect what's happened is they've put in another couple of amendments to what's being discussed. And my learned friend says, well, this supports his case. He says there's a difference between 350 and 250 million of 100 million. And that's the number that he said was promised. But that is, with respect, a specious argument, because these documents have got nothing to do with working capital. This is a difference between the parties about when the OBN security is going to be released. So this explanation is, in fact, this position that's being taken is actually inconsistent with the defendant's case. Because if we recall, what's the defendant's case? It's that there was a promise immediately to release the 100 million in working capital, or at least by March 2019. The position on sell down is that Bank will release security if it sells down its exposure. So whether the target was 250 or 350, release, what's being agreed, is conditional on achieving a reduction in exposure. It's about releasing security. It's not about providing any further finance. So there is nothing in that which could support a case that there was some further promise that was in contemplation. And then we also have some internal bank summaries from Noor Bank. You find them at D 1025. It's the bottom of an email there, I think. Starts on 1024, but you'll see there's a summary on 1024 from Mr. Mohammed Naqvi, who was at the meeting, to Mr. Umar Gufran, copied to Sheikh Faisal Sheikh. And you'll see what was said internally at Noor about what happened at the meeting. Syndication valuing was successfully closed with Noor LMA participant at 500 million. Our final hold has to be brought down to 250 million within 6 months from syndication. And then talks about the additional security that has been obtained. And so if there had been a side agreement to commit more, another 100 million, that would have to have been in there. Otherwise, in effect, the case becomes not just these people at the meeting made promises they just knew Noor Bank wasn't going to comply with. It becomes they did that and then they hid it from Noor Bank. All right, and then we move forward a little bit in time, and just on the next page, 1026, we see what happens in March 2019. Now, we've already seen a little bit fragment of this because it was referred to by the judge in his judgment, but effectively several months then later, well, a few months later, we're now in March. The defendants then wrote to the first claimant, which is the global agent Emirates NBD for the syndicate, and said they'd made a mistake in not asking for working capital. And they said, please, can the syndicate lend? That's what they said. We made a technical mistake by assigning all of our projects to the syndicate instead of the agreed 70%. On top of that, we overlooked the working capital requirements of the projects that are assigned to the syndicate. That's their position in March. They've overlooked working capital. And correspondence like that is fundamentally inconsistent with an allegation that the defendants at Noor Bank had agreed that Noor Bank would lend 100 million in working capital. And then we've got Mr. Vig's email, which again was another document that you were shown and told that it somehow supported the defendant's case, but it's the opposite. We have to go, I'm afraid, to D 1454. And you see there, Mr. Ijaz sending an email on the 24th of March. And he sends it to various parties, basically to the syndicate. And he says, hope you're doing well. This refers to recent telecom. While closing the syndication, we overlooked the working capital requirements of the 70% projects that are assigned to the syndicate. Due to the lack of necessary working capital lines, our syndication cash flows at the moment are under stress. Currently in communication with majority syndication banks for the arrangement of working capital lines for 70% of the projects. So again, this is Mr. Ijaz saying something which is, again, just totally contradicting the case that's put. He's saying we overlooked it, and now we're asking the syndicate to provide it. And then Mr. Vig comes back, Mr. Rishi Vig, also at the meeting, and says, this is at the same page, 1454 at the top. This is factually incorrect statement. We did not overlook the working capital requirement. Our understanding has always been to get working capital after the closure of the syndicate bilaterally. It was mechanism that needed to be finalised. Borrowing agreement talks about 350 million of working capital lines, which certainly can't be supported by 30% of the business. So he's saying, we didn't overlook it, but we were always intended to get it later. We always intended to get working capital afterwards.
That's unhelpful for the defendants, isn't it?
Yes. Yes, my learner friend presented it as a helpful email that supports his case. But he showed it to you at pace and said, oh, well, that supports me. But it doesn't. It's very unhelpful. There's a disagreement.
Yes,
Sorry.
forgive me. I'm just summarising for my own, to get into my own mind. The lower email says it's a mistake. We overlooked it. And I'm not concluding anything. I follow your point that it's difficult to reconcile a mistakenly overlooking something with an agreement. But then it gets worse, you would say, because Mr. Veek comes back and says, hang on, it's not a mistake at all, but we were going to do it differently.
Yeah.
Have I understood where you're going?
Correct. So, but both say we didn't do it. One said we didn't do it by accident. One says we didn't do it, but deliberately.
Yeah.
Yeah.
Okay.
It's not just that it's difficult to reconcile. It's just wholly inconsistent. And so, again, I repeat, you were taken at pace through this documentation and told that it supported it. But when you look at each one of these, they are fundamentally inconsistent with the case. There's more. I've shown you the minutes of the 14th of May 2019 meeting. If you recall, they're the document that was sideways. And that I remind you is at 10, let's go to it, D1027. And you see paragraph 3 on page 1028. At the meeting, AFM requested the following working capital facilities. These are the defendant's minutes. So there's no suggestion of any complaint that this should have happened already. And then paragraphs 4 and 6 show that the banks are saying this is conditional. You have to put the chairman has to put equity in. Otherwise, we're not going to do anything. And that equity is never forthcoming. And I've shown you, I think you were also shown the next document, which is at page 1030, D1030. And again, told that it supported the defence, but it doesn't. This is a document from July 2019, and it thanks them for support. Thank you for your continued support in regard to our ongoing banking relationship and the existing facilities that have been made available to the BBIH Group and its subsidiaries. As you're aware, the current economic conditions have severely strained the liquidity of many companies of the region, and the BBIH LLC Group is no exception. A recent lack of working capital facilities being extended to our group companies at this crucial time, which has had a spiralling impact on the operations of the company. And given the current issues facing the group, BBIH has very recently appointed Deloitte to support in the financial restructuring of the group's liabilities. And this will provide restructuring options and so forth. So what they're saying is we can't get working capital anywhere. Economic conditions have become difficult. We're going to have to go back and do another restructuring. And we've appointed Deloitte to do that. They're not saying you promised us working capital and you didn't deliver. Just isn't in any of these documents, and it would be. And again, you were shown the bits of the Deloitte report as well, which begins, it's the next document, it starts at 1032. And 1044 is the relevant part. And you'll see in the panel on the left-hand side of that page, under the heading Background Overview, the second paragraph down, a debt restructuring and syndication deal with 7 lenders, totaling 1.7 billion in January 2019, did not result in any additional working capital facilities for the group, which is now facing significant financial challenges. And in the middle of the panel on the right, or top of the sort of the third bit down, where it says January 19 debt restructuring and syndication, in January 2019, a syndication deal was finalized with 7 lenders across the group, representing 1.7 billion dirham of the total 3 billion debt exposure. Management advised that the primary objective of the syndication had been to offer additional security in NBD to lenders in order to secure additional working capital facilities. However, whilst additional security was granted to certain lenders, no additional working capital was secured by the group. It doesn't say no agreement, nothing was forthcoming. My own friend tries to spin that language, but one can always try to attribute different meanings to words, but on its plain reading, it's saying this is the restructuring advisors saying this is our understanding of what happened in January 2019. They didn't get any working capital, didn't get any commitment to working capital. That is what they are being told by the group, presumably, you can infer. So we say it's inconceivable that if there had been a promise by Noor Bank to provide working capital at the PALM meeting, that it wouldn't have come up in one of these documents or in writing somewhere else. And again, I mean, my learned friend's submission is somewhat loose again on this, because he says, oh, well, the documents show the defendants demanding working capital. And with respect, they never do anything of the kind. There's no complaint that you can see of a demand. There's no complaint that nothing's been provided, and there's no demand. There's a request at various stages, but that is inconsistent with the case. The first, as I say, the first time you see this alleged is in the defence and counterclaim. That's on the 9th of March 2021. So more than 2 years after the facility is concluded. More than, or just about 2 years, just under 2 years after the deadline for that's alleged for the provision of this working capital. So just to summarise, if one goes through each of the reasons why the judge looked at this critically and said, this does not stack up, this is just not credible, this cannot go forward to trial, each of those is accurate. It is a vague account. It's not going to be improved. It is inconsistent with itself. There's no support in the documents, but worse than that, there are a series of inconsistent documents which on their face are a complete record of what was agreed. And one just asks, I mean, of course, there's a dispute of fact, but if you accept the principle that there are certain types of dispute of fact that can be resolved because all the documents are inconsistent, if you accept that principle, then if this is not that case, it's difficult to see what the case is, where you couldn't just stretch out your obligations to trial by coming up with an allegation of this sort in a defence 2 years after the event. And that's why there is this facility in the rules to make those summary determinations when the allegations are not credible, by predicting forward to trial, well, what's the state of the evidence going to be? What's the outcome likely to be of that? So we say that the judge was absolutely justified. It's not a mini trial. He's not saying I've got 15 documents this way and 15 documents that way and competing witness evidence in both directions. He's saying this is what founds the case. Is it consistent with the documentation? Is it credible in light of that documentation? That is precisely what he's entitled to do and what he did. So that's what I had to say on ground 6. What is left is ground 7, which is a discrete area of its own. I don't think it's time for evening prayer yet, so I was going to make a start on that, and then we can break at any time, Chief Justice, that you would find convenient. Please just give me a nod. So this is about the Islamic lending, and just to put it in context, the whole of the lending was for 1.7 billion dirhams. Now, out of that, 751 million was Islamic lending, and it was lent by the 7th and 8th claimants, but the 8th claimant's interest has been assigned to the 9th claimant. There was an assignment that went on, and in effect, the 8th claimant it still exists, but it's not trading at the moment, I think. So this ground is only relevant to the lending or the claims being advanced by the 7th, 8th, and 9th claimants, not the conventional lending by the first 6 claimants. And logically, it could only relate to the profit, that is the equivalent, the Islamic equivalent of interest on those loans. The profit element of that is about 130 million dirham. So otherwise you'd be saying, well, they took the 750 million and they get to keep it because the arrangements were void. They didn't get to keep it. The only question could possibly be the profit. Now, I preface this by saying there's a considerable amount of confusion in the way in which this case has been put. Possibly it's my confusion, but the pleaded case is slightly different from the way it's been put elsewhere. But in fact, the way it was put to you orally yesterday is consistent with the pleaded case. And the way it is put in the pleadings and in orally is like this. Certain Sharia standards have been incorporated into the contracts by reference. So those Sharia standards become terms of the contract. That's the starting point. And then because the facility was designed to operate in breach of one of those standards, it's just one now, that renders the whole of the facility void. That's the way it's put, as a contractual effect on the contract via the incorporation of the standard into the into the contract. Now, in their written argument, they suggest an alternative case. In effect, they say, well, they don't have to get to incorporation. Why not? Because the two banks, Noor and the Commercial Bank of Dubai, they say entered into these agreements in breach of regulatory duties. And so there's a sort of public policy way in which the contract becomes void, whether or not it's incorporated. Now, that wasn't advanced to you yesterday, and it's quite different from the way in which the case is advanced in the pleading. It's not pleaded on that basis. It all turns on incorporation, as we understand it. So I will pick up that sort of alternative position at the end of my submissions. But as I understand the case as it was put orally, it all requires that this particular Sharia standard be incorporated as a term of the contract. And when my learned friend dealt with that question of incorporation, sorry.
I'm so sorry, Tom. Just to say, I just wanted to say I did rely on our written argument. I made points orally, but I also relied on our written argument. I made that clear on every occasion.
Yes. All right. Thank you. Okay. So there's no sorry.
Sorry, Mr. Martin. Can you tell me what does the provision that the standard that you are speaking? The standard. What does actually say? What is the wording of that standard? Standard that requires you comply with the Islamic standard. What does actually say?
Yes. Well, I can come to. I was going to come to that a little bit later, but let me show you it now, just so you've got it in mind. It's in bundle F, behind tab 43. So for my junior assistants, it is, I think, F1636. So you'll see the Sharia standards start at F1630. And then at F1631, you see Sharia standard 30 on monetization. And then if we go down to F1636, we see the standard itself. And the particular...
which one is the relevant? Which is the relevant part? The relevant standard they're complaining about.
It's 3/2.
3 said the institution should not perform monetization for the benefit of conventional banks when it discovers that such banks are going to use the liquidity for interest-based lending instead of Sharia. And this particular loan is interest-based. Is that what it is?
No, there's no complaint about the structure of the loan. So the loan, so the complaint is about the use that was made of the money.
Where's the provision that prevents the use, the way the money is being used? Where is this standard?
That's what they rely on. So they rely on this to say the effect of this particular standard is that you cannot lend to somebody on using Sharia compliant instruments if their intention is to use that money to discharge a conventional loan. That's the case. But that's not what it says.
The conventional loan is interest based.
The loan that's being paid off.
Yeah, that you are going to be paid off is interest based. So yes. I cannot use this loan to settle, and they're saying that is in breach of 3/2.
Yes. Now No, just. I mean, we'll come on to whether or not that would be a breach in it.
No,
Sorry.
I just want to
My learned
understand
friend wants to say
contention.
something.
I just want to understand what the contention is.
Absolutely.
I was just saying that my Chief Justice understands it exactly.
Okay.
Yes. Thank you. And so that's the allegation. Now my learned friend said yesterday there's no dispute that that's what happened. Well, that again is extremely loose. Because if you think about the Islamic lending, how does it operate? It operates as a series of contracts. 3 contracts were by the time we get to the alleged rescission. So there's one in December when the first lending is sent out. Then there's another one in April, and then the final one is in July. So the complaint has to be about the July one because the others have happened. So what is the use that is being made of the lending in July? It's being used to pay off the previous Murabha contract under the same lending. So none of it makes any sense. But assume that it could be on the facts asserted that somehow this money was being paid to pay off conventional lending. Is that a breach in and of itself of the standard? Well, we know it's not, and I'll come to Mr. Edge's evidence in a moment. But below the standards, you will see that there is some official guidance, and the guidance, the relevant part of the guidance is at page F1644. And if you look at the last sentence of that, monetization may also be used as a means for helping the clients to dispose of their previous interest-based debts after ensuring that they have developed genuine intention not to deal in usurious transactions anymore. My learned friend's case is that in and of itself, and Mr. Edge's evidence, we'll come to it, is that in and of itself, using Sharia murabhas to repay conventional debts is a breach of the standard. But the guidance, the very guidance that you get, says in and of itself, that is not the position. Because it does say it may be used, it's conditional, but in and of itself, that use is not a breach of the standard.
But the last phrase is important, after ensuring that they have developed genuine intention not to.
But it's not important because it's no part of the case. We're not here today dealing with that aspect. The complaint is purely and simply, you allowed them to use that money to repay conventional lending. That's a breach of the standard. But the standard says that there are circumstances in which that is permissible. So there's no breach of the standard. But I've got my submission somewhat backwards because before we get to this stage, we have to show that this is a part of the contract. So my learned friend has to deal with his incorporation argument. And the way that he does that is by mischaracterizing the judgment. So you were told that the question of incorporation in the judgment came down to whether, as a matter of fact, the facility was an existing product or a new product. That was what he said. And that was simply wrong. Now, let me walk you through how this arises and how the incorporation works and what the judge actually decided, and then I'll come back to that assertion. It's got nothing to do with considering that factual question. My learned friend simply mischaracterized that. The factual question was a hypothetical issue the judge raised when considering the consequences of a breach of the standard, and nothing to do with the question of incorporation. So let's look at the incorporation and how it's put first. We have to start at page D203. Apologise again because I'm slower than you are, but this is the Master Murabha agreement. I think this is the final draft, but I may be wrong. But in any event, the wording is the same. And it's recitals C and D that are relied on to incorporate these standards. And C says, under the facility, the investment agent will purchase commodities and sell them to the purchaser at the cost price, together with a profit element on a deferred payment basis, with title passing immediately to the purchaser, and the particular provision relied on, all in accordance with the Sharia. And then D, each party has independently reviewed the finance documents for the purpose of ensuring their compliance with the Sharia and is satisfied that they do so comply. And Sharia is defined.
It might help here. I think my learned friend is actually addressing the bridge loan here.
I'm so sorry, but it's the same. The wording is.
It is the same. I think the definitions are different. It'd probably be better, safer to do it. Probably.
I'm sorry. That's a mistake in my referencing. If we go to page D676, the wording is the same. So we can start that again. Page D676. This is the master marapa for the syndicated lending, and again, the wording is precisely what I've just repeated, which is that my learned friend says the words "all in accordance with Sharia," with the Sharia, introduce as terms of this facility agreement the standard that I've shown you, and the Sharia is defined. You're going to have to find that because the reference is wrong again, but it's at page D680. That's just meaning the rules, principles, and parameters of Islamic law. So no particular standard is referred to. And what the defendants say is two things. They have to make out this case for incorporation. Firstly, that reference to the Sharia must be a reference to the AOFI standards, specific standards that I've just shown you, particular standard number 30. And secondly, by referring to them as they did, all in accordance with the Sharia, those standards are incorporated into the terms of the facility agreement. But just pausing there, just think about how that operates. What they say is, because of the way the master marapa was structured, it was structured in a way which was inconsistent with the standard. The standard is incorporated by these words, and the effect of that, in total, is that the whole contract is void. That's their case. So the case is that you have to construe this recital at page 6D676 in a way which renders the entire contractual arrangement void. That is totally commercially unrealistic, and is one that a court is always going to strive to avoid unless it's driven to it. And that's a point that the judge made in his judgment, paragraph 87, B34. So the question is, are you driven to that? Are you driven to that conclusion? And the answer, we say, is very clearly no. The judge's answer was that these are just, all these recitals are doing is reciting the agreed position. They're like the basis for contracts. And so actually they set up an estoppel. They don't say this must be, otherwise it's going to be void. We'll come to the estoppel and waiver arguments later, but that's effectively the work that they are doing. And that's what the judge found. If we go to his judgment at page B33, paragraphs 81 to 83. So he starts at 80. He says, this is an English law contract. So that's the law he applies when construing the document. And then the first question is, were those principles, those specific principles, incorporated? And then he goes through them, the recitals, 81 and 82. And then he says 83, the effect of these recitals is not, in my judgment, to incorporate the AOFI standards into the loan document, but to recite the agreed position, and explains that. And at 87, he gets to his point. Well, wouldn't it be strange if the result of incorporating a term, interpreting a term in a certain way, made the contract void? You would avoid that. Now, in terms of incorporation, my learned friend relies on a single case, which is the target rich case. And you may remember that there was some discussion about that in his submissions. And I'll show you the relevant passages of that. But again, this is not a case that supports my learned friend. It fundamentally undermines his argument that that sort of reference that you see in recital C is sufficient to introduce regulatory requirements into a contract. Target rich, you will find at bundle F, and the page is F1128. And if we start at the bottom of that page, there's just 2 paragraphs of that case which are relevant. You were shown these before, but I'd just like to take a little bit of time over them. Paragraph 94 is where we start. And the judge is considering the circumstances, the question of whether or not reference to regulations, regulatory requirements, incorporates those provisions into a contract. Paragraph 94. There are some cases in which a background set of rules has been held to be incorporated into an agreement by the use of express words, reference to a particular case. In that case, Mr. Justice Thomas held that a document which stated that transactions would be governed by a code of conduct established by the Bank of England achieved the incorporation of that code. And there's another one where the words were subject to regulatory rules. But paragraph 95, in a number of other cases, including several of those which I have summarized above, attempts have been made to argue a case of express incorporation, normally of the Cobb's rules. That's a particular financial regulation in England, or England and Wales, on a more general basis. In broad terms, claimants have sought to fuse the existence of regulatory obligations with contractual rights agreed between the parties by drawing attention to instances where regulatory rules were mentioned or even described within a set of contractual terms. Such attempts have been uniformly unsuccessful. Whilst the court will give effect to clear expressions of incorporation, the cases demonstrate a consistent recognition that regulatory obligations are distinct from contractual rights, that they may operate in parallel without fusion, and in particular that mere references in contract terms to the existence and content of regulatory obligations will not, or at least will not likely, be treated as an incorporation of any specific obligations mentioned, let alone of the rules as a whole. So the approach in England is real reluctance to incorporate these sorts of background sets of rules into contracts unless there is express provision to that effect. And here there are 2 problems. One is there's no clear reference to the AOFI rules themselves, just to the Sharia. And the Sharia is not given any particular, it's given a definition, but it's not by reference to any particular set of rules. And secondly, there's no statement of incorporation. And then there's also the logical problem that if you were to follow both of those points in my learned friend's favour, you get to the effect of your construction is that the contract is void. And there's no getting away from that for him because that's what he wants you to find. And so you would strain against that. And in the face of this, the criticism of the judgment is, I'm afraid, just diversion, because it's not dealing, the bit that's attacked is not dealing with incorporation. I've shown you the bits that deal with incorporation. What's attacked, you'll find at B35, paragraph 91 of the judgment. And here, what the judge is doing is he's looking at the question of, well, all right, assume that it's incorporated, assume that it's breached. What is the effect on the judgment? And so if you look down to the middle of that paragraph, you see that the judge says, it is thus impossible to say that the effect of the resolution is to nullify finance documents which do not meet these standards, since the resolution provides for a period of time in which to remedy products which have been issued contrary to those standards. Inevitably, there will be documents in circulation which do not comply until they have been revised, and there is no suggestion that the transactions effected thereby are a nullity. Moreover, it cannot be said that there is a breach of any obligation in concluding an agreement in December 2018, which is inconsistent with those standards because of the periods of grace provided by the resolution itself for provision of products. So he was dealing there with the point that I had been making below, which was that the effect of breach of the standards can't render an agreement void because there was a resolution about which dealt with a phased introduction of those standards. And it dealt with a situation where you would have a non-compliant document that was valid and therefore and continue to be in effect. So my learned friend's attack, I'm afraid, on that particular paragraph misses its mark completely because it's not about incorporation at all. So ultimately, the case on incorporation is just it's effectively assertion. We say it's commercially nonsensical and it's contrary to the case law. Now, on the pleaded case, that is the end of it, because it all depends on incorporation. My own friend intervened to say, well, he still maintains his alternative case, but that is not how the claim is put below, and it isn't. And for that, we can see that you'll see the relevant parts of the defence and counterclaim. We don't need to go there, but they're at C46 to C51, paragraphs 94 to 107, and it all turns on incorporation. And you can see it from the appeal documents themselves, the grounds of appeal. Page A6, ground 7. The judge was wrong to find that there was no real prospect of the defendants succeeding on their case on Sharia compliance. And then number 1, the judge erred in fact in holding that the syndicate facility agreement was a product or service currently used by Noor Bank or CBD in the absence of any evidence on which such a finding could be made. That's the point where there's this misguided attack on paragraph 91 of the judgment. But look at the next one, paragraph 2. Consequently, the judge erred in law in holding that Sharia, as used in the syndicate facility agreements, did not incorporate the AOFI standards. And then the rest of it is about his findings on Sharia. Actually, 3 is about his addressing the Sharia, the question of Sharia compliance at all, or the question of compliance with the standard, and 4 is about looking at the standard itself, and then 5 is about the estoppel arguments. So the way that the case was put and the way the appeal was put is all about incorporation. Now, my learned friend doesn't deal with it orally, at least, and I'll come back to it. But ultimately, if it's not incorporated, we say that's the end of that aspect of the case. So I was going to come on then and just deal with those further 3 bits of the appeal and Mr. Edge's report, and also deal with the case as it goes to the effect of a breach. In terms of timing, I would expect to take about half an hour and possibly 45 minutes. But I can make sure I take half an hour. Would now be a convenient time for the Chief Justice to take a break?
Stop now. Say about 15 to 20 minutes. Come back in, say, 10 past. Is that all right with you all? That gives me 20 minutes. Fine with you?
Well, I'm in your hands. Yes, absolutely.
Okay. Mr. Justice French and Mr. Peter Gross, is there any time that you want? I know we have got a limited time, but do you mind if we extend, by 5, 15, 20 minutes? Do you have any problem with that, Mr. Justice French?
Oh, I always find that time is like a vacuum to the lawyer. It's filled. I prefer not to offer extensions.
I know. I realize that.
I think we've well trodden the ground. So it's up to you, Chief Justice.
So we can be a bit flexible, a few minutes flexibility.
I'll expedite. I've heard the comment, but so I'll move forwards.
And so have I.
So we come back 10 past the hour.
10 past the hour. Thank you.
Thank you. Thank
you. We've got you back perfectly. I'll just carry on in the interest of time.
Yes.
So Chief Justice, just to explain where I was, I reminded you that I'd shown you the standard. That was the first question you had, and the guidance that there was. And my point, the appeal on this point is that to the effect that the judge should not have read that standard and drawn any conclusions at all. It wasn't safe for him to do so. And my answer to that, and the judge's answer, was that this is a question of English law. So if you incorporate these provisions into the contract, then he's entitled to interpret them just as you would an English law contract. But the specific complaint that is made is that there is a particular direction from the registrar which says that the court must not decide any issue of Sharia law without expert evidence. That is the direction that you'll find. I think my junior has brought it up at F1626. And I mean, we make points on this in written argument, and I'm not going to go into it in huge detail, but we say that the judge, of course, is not bound by a registrar's direction. They have no status in law, and I think my learned friend accepts that now. It would be, we say, deeply unsatisfactory if you could simply assert as a defence some principle of Sharia, and that was enough to carry you forward to trial. I'm being interrupted. I keep thinking Mr. Fraser wants to say something, but he keeps putting his camera on to do so, but it's not working. So I'm going to carry on. There is, I mean, I don't know whether maybe he wanted to say his case is that there is some legal obligation on the judge to follow a registrar's direction. There's nothing in the rules, nothing in the laws that acknowledges them as being in any way binding on the court. They're merely guidance. I think
you said something about Mr. Fraser. Then
yes.
His camera appeared. Then he went quiet. So if you just put what your case is.
Yes, I'll do that.
He's muted, so he's not going to speak to us. His microphone is muted. Mr. Marcus, can you just continue?
Yeah, I will.
I think under the rules there is a provision. I was wondering where the legal authority for the registrar to make practice directions came from, and I think under the rules, I think it might be 3.18. There's a provision under which the Chief Justice can authorise the making of the making of directions by the registrar. But in any event, it seems to me that would probably be overtaken by the approach adopted by the Court of Appeal, wouldn't it, in Nest Investments and also earlier on in the Fidel case?
Correct. So yes, correct. So the position in the DIFC court's been settled since the Fidel case. If you have an issue of non-DIFC law, then it is simply treated either by way of submission. The court can, if it deems it appropriate, get expert evidence to assist, but it's not obliged to do so. It all depends on whether or not the judge feels confident to determine the issue. That's been the position since Fidel. It was described there as the sort of arbitration approach as opposed to the English approach, which always treats foreign law as a matter of fact, and therefore you always have to have a cross-examination and evidence on that. That's not the position in the DIFC. And I've read the judgment that your lordship mentioned, the Nest Investments judgment, the recent one from the Court of Appeal, and I don't read that as saying anything different. I think there was a question there as to what to do with findings when the judge has had the assistance of experts. But even when you treat expert evidence on these sorts of issues as fact, it's always still a sort of, and put it like this, a funny kind of fact.
I think the problem is that people try to shoehorn these sorts of findings into either fact or law because it has some implications for appellate review. But
yes,
I think in Nest we sort of said that, you know, it's really what's most helpful to the judge, and usually the expert evidence will very often be in the character of submissions, but whether it is or not.
Right, exactly, and that's essentially how you could, at its highest, treat Mr. Edge's report, we would say. So then that's all I was going to say about that. As to Standard 30 itself, which I've shown you, the third issue is that the defendants say that the judge got the analysis of Standard 30 wrong. Now, they produced no evidence and, in fact, no argument on this below. None. They just said you can't touch it because it's Sharia. And it won't have escaped your attention that on this appeal, the defendants don't actually themselves in their skeleton argue the points at any stage. And you didn't hear any oral argument on it at this stage. All that was said was we rely on what Mr. Edge says. So in theory, there are two questions. One is, do you admit Mr. Edge's report? And if you do, or if you treat it as argument, do you think he's got a real prospect of success on it? Now, obviously, it does matter to an extent whether you admit the report, because you might say then, oh, well, it's an issue of fact and off to trial we go. But if it's argument, you can decide it now. And it's as good coming from him as it is from me. As to the admission of the report, we say you should refuse it. Why? Because it doesn't meet the test of fresh evidence on an appeal. The defendants accept it doesn't pass what's known as the Ladden-Marshall test at the first stage, which is generally you have to show that you couldn't, without reasonable diligence, have produced it below. But they say, oh, well, there's a discretion. Now, what the authorities say about this, and I won't dwell on it, is that if you can't meet the Ladden-Marshall test, then that places a very great impediment in the way of a party seeking to adduce evidence on appeal. That's the Muscat case. We don't need to go there. It's a tangential point. It's at F129, paragraph 26 of that judgment. Essentially, we say the defence would need an exceptional reason to justify fresh evidence on appeal. Now, you have an explanation from my learned friend why he says there was no evidence below. He doesn't produce any evidence to support it. My learned friend says they didn't produce the report because they believed that the registrar's direction meant that the judge couldn't rule on Sharia issues without expert evidence. And so he didn't need any expert evidence, he just needed his assertion. Even if that is an accurate explanation of why, it's not a good reason, we say. They should have appreciated that they might be wrong about that and ensure they had the evidence that they relied on at the hearing. Our view is that that is not actually how it happened. It was an attempt, really, when seen properly, to, we say, one can infer that it was an attempt to ambush the claimants with the point, because the reference to the registrar's direction was first raised in skeleton argument the day before the hearing. So it was only ever said the judge cannot look at this issue at all the day before the hearing or on that basis. So it's we say at least open to the court to infer that they deliberately didn't produce expert evidence in support of their case, because they took the tactical decision that they would instead, because if they'd produced expert evidence, they would have had expert evidence in response, but instead they saved it up to the day before the hearing. But we say anyway, even if you can somehow explain away that, we say the report just doesn't meet the second or the third parts of the test either, because it's got to be capable of making a significant impact to the outcome of the case. That's the second part. And it's also got to be effectively credible evidence. And we say it isn't. And I'll come on to look at Mr. Edge's evidence in a moment. But we say you should refuse to admit it. And on that basis, unless you treat it as argument, then there is no basis for challenging the judge's decision that standard 30 was not breached. And this whole thing falls away. So let's look at it as if it's evidence or argument or whatever it may be. What actually does Mr. Edge say? And I'll look at this briefly. I know you've seen it previously, but it is quite a remarkable document. If we go, I'll start you, if I may, at page A51. So I'm going to summarize this, and no doubt we can read it at leisure, at length, at another time. But paragraph 11, he starts off by giving you his views on the meaning of the registrar's direction and the effect of it. So he's giving you advice on DIFC law at this stage, which obviously is not within his remit. And then at paragraph 12, he goes on to express a view on DIFC conflicts of laws, in effect, because he's telling you what should be the applicable law to the question of contractual waivers and the effect of a breach. This is an English law contract. And of course, the questions of applicable law, governing law, that's a matter for the law of the forum, the DIFC. That's governed by what we all know as the waterfall provisions, which don't allow us to go outside of the agreed terms of the contract. So it's a matter of English law. So again, he's going well outside his remit there. The particular provision that is relied on is paragraph 15. I'll come back to 14 in a moment, which is on page A54. So what he just says is the judge is wrong, is interpretation of the AOFI standards. AOFI standard 30 is not limited in the way the learned judge suggests to Islamic banks directly providing Islamic finance to conventional banks. a limitation of this nature would negate the effect of the standard to the whole practice and market for murabha. And that, he goes on to talk about another violation of a new standard, but the second half of that paragraph is irrelevant because it's not said that that standard was in place at the time of the contract. So that is it in terms of the case. It's just a pure assertion and based on, not on any authority, not any specialist knowledge, but what he says would be the logical consequence, which is that it would negate the effect of the standard. We say that just doesn't logically follow at all. There's obviously a difference between, on the one hand, an Islamic bank lending capital to a conventional bank directly to allow it to use that for banking purposes, conventional banking purposes, and on the other hand, an Islamic bank lending to a customer who may then use that lending to move on from his conventional lending arrangements and enter into Islamic conventional arrangements. Importantly, there's no reference to the guidance that I showed you about this, which does indicate that in certain circumstances, the standard permits the lending to be used in the way that he says is just completely unacceptable.
On the face of it, it looks like a purposive construction argument, which one might apply to any free provision, I suppose.
Yeah. So the way that one interprets a contract is, as we know, an iterative process. You test the different constructions by reference to their consequences and the effect that they would have on the relationship between the parties. So that is what we do in English law. That is what all lawyers do in all contracts. There's nothing specific about this that he is able to identify as confining this to some sort of specialist Sharia interpretation point. But there is also no explanation as to how the relevant lending could breach the standard at all. So you'll see further up at paragraph 13, which is the page A52. He accepts that the master murabha agreement is not a murabha contract itself as such, but it sets the provisions for the murabha contracts that follow and for murabha transactions that take place in onshore Dubai. The provisions and so on, he says, are subject to that. So his evidence actually is that none of this can affect the master murabha. It can only affect the individual murabha contracts which come after that. I don't know whether I've explained that. But the master murabha is effectively a framework agreement. And then within that framework, you then have separate and distinct contracts. So what he's saying is that those distinct contracts are subject to this particular condition. But the problem with that, as I've said previously, is that by the time you get to July, the master murabha lending for the live contract hasn't been used to discharge conventional lending. It's been used to discharge the previous murabha contract. So if, as you accept you must, he accepts you must, you carve up the murabha lending into those little, sorry, I say little, but into distinct time-limited murabha agreements, then the one that has to be attacked is the last one in place, because that's the one the banks are pursuing. And so if that's right, then the case doesn't get going because the money has not been used to discharge conventional lending. All right. There is also, and this was a point that the judge made in the judgment, there's no explanation of how this renders the contract void. None. Why does a breach of a term of the contract render it void? Why does the breach of the term of a standard render it void? And that's a point that was made by the judge, and I'll give you the reference. It's paragraph 87 at page B34. We don't need to go to it. Now, you were shown one paragraph of Mr. Edge's evidence, which is supposed to contain this explanation, and it doesn't. So this is paragraph 14 on page A53. So what he says is that he talks about the resolution, and the resolution which brings in the EOFI standards. That causes them to be binding on the banks, he says. That's the first sentence. Resolution came into effect before the MMA, provided a grace period. And then he says, Article 82 of the central banking law says that not following the HSA principles will have regulatory consequences. And this is about as high as it gets. He says this, but that does not mean it will have no civil consequences. He doesn't say that the consequence of a breach of Resolution 30 in this way will lead to the contract being avoided. He says the fact that it will have regulatory consequences doesn't mean it won't have civil consequences. And then he goes on and says, he refers to a particular case, which is Cassation Case 2020, 898 of 2019. I'll look at that very briefly, if I may, because what he says is, in that case, the Dubai Court of Cassation decided that violation of the strict principles of Sharia would be taken seriously and could lead to the nullity of the relevant Islamic contract, in that case, Murabha contracts, not similar to these ones. And so it's, the high point of his evidence is to say, well, in some circumstances, breaching Sharia principles could lead to the nullity of an agreement. But he's not saying under English law, an English law agreement. He's saying as a matter of UAE law, that could be the effect. And if we look at that case, I won't take you through it in any detail. If we go to A76, you'll see the case there is Al-Nabudi and Phoenix Holding. But if you take the time to look at that, what you will see is, firstly, there's no mention of the AOFI standards in that at all. It's a point my learned friend suggested and then corrected himself later in his submissions. And it doesn't look like either party is in fact regulated. So what this has got to do with the current case is not clear at all. But that was a case where the loan appears to have been governed by Dubai law. And the problem, if you see it at A79 at the top of the page, I think, sorry, it starts at A78, that's it. And this is the case that's being put. You see it at the bottom of A78, top of A79. Essentially, what it is that a Murabha agreement has to be a sale agreement. That's how it has to be structured. And this was not one at all. So the attack was on the wholesale and the structure of the transaction. It wasn't structured as an Islamic finance. It was structured. It wasn't structured as a sale at all. So yes, okay, fine. Under UAE law, there may be circumstances where if you have a Murabha, it'll be void if it doesn't actually comply with the basic standards of Sharia. But that's a long way from making out any kind of case, or even the beginnings of a case, which suggests that the breach of this particular standard, that is lending to someone so that they can discharge conventional lending, will lead to the whole thing being void. To be clear, my learned friend said, oh, it's admitted that that was what was happening. It's not admitted. That's not accurate. You will recall that there was a 500 million dirham bridge loan. That was Islamic lending. So we've got 750 million dirhams of Islamic lending. At least 2/3 of it could be used for discharging the bridge loan. I don't have for you the numbers as to what everything else is, because we're not dealing with this aspect of the case in factual detail at this stage. When my learned friend said it was admitted that it was used that way, that's not accurate at all. But the point is simply that there would be an issue at the first stage of lending as to whether actually there was any breach of the standard at all. But when one gets down to the second and the third stage, there can't be an issue, because you've got effectively renewal and fresh Murabhas being raised. So we say, even if they can rely on their expert report, even if it's treated as argument, doesn't get them to the conclusion that non-compliance with the AOFI standards would necessarily render the transaction void. Now, when they deal with my arguments on waiver and estoppel, and I'll come on to those in a moment, my learned friend does rely on a particular passage in Dicey, the effect of which is that an English law may treat a contract as void if it is in effect an adventure to breach foreign law, if it's a deliberate attempt to breach foreign law. But there's no allegation along those lines at all. let alone any evidence that that was the position. That is not what is being asserted here. I do apologise. I just need to close the door because there's a little bit of background noise. I'll just be.
I would point out at this stage, my learned friend is eating into my reply time, so if you could wind up as swiftly as possible, I'd be grateful.
Very grateful. My learned friend overran quite considerably yesterday, so I'm hopeful I'll have the indulgence to give you the next 5 minutes. All right, so we're just not in that. We're not in that zone. Waivers, very briefly. The judge concluded that there was a contractual estoppel or waiver in relation to any complaints that the Islamic facility failed to comply with Sharia. You see the clauses that are relied on in the judgment. I've shown you the two recitals, but if you go to the judgment at B33, in paragraphs 84 to 85, you see the others. And they are express waivers. Paragraph 84 recites clause 13 of the Master Murabha. The purchaser waives any defences he might otherwise have in any jurisdiction based on the non-compliance of the Islamic finance documents with the Sharia. This waiver applies irrespective of any provision of Islamic finance documents to the contrary. And then there's something similar in the common terms agreement. So the judge said, well, even if there were these problems, you're not entitled to raise them. Now, in response to that, my learned friend says, oh, well, those clauses are contrary to public policy. But the actual pleaded case is about incorporation of principles, not about illegality. That's what the judge was dealing with. If you incorporate terms by agreement, that's the effect of them, then you can also exclude their effects by agreement. There's no public policy considerations that even arise. And more generally, there's no expert evidence and no authority to support the assertion of public policy. There's cases in this court where the courts have said, well, look, that's quite an extreme submission. And if you want to make that submission, you need to demonstrate it as a matter of UAE public policy. What my learned friend relies on is an English case called Parmar. He's provided that in advance of the hearing and suggested that it helps him on this particular point, but there's been no explanation of it either in writing or orally. I don't know whether he's planning to deal with that in reply, and so not give me a chance to deal with it. But if you read that case, I don't know whether it's relied on. If you read that case, you'll see it. The effect of it is that there is a regulatory regime in England which expressly prohibits, on its true construction, the exclusion of liability in certain circumstances. That arises in Cobbs. You can see that at page F713. But nobody has pointed to any kind of regulatory provision that would be applicable in this case, which says, in terms, the effect of a breach of this is the contract is void or the waiver is void or whatever it may be. So as things stand, the freedom of contract that exists in the DIFC and in DIFC law permits parties to say, I'm not going to take a Sharia point and to be held to that bargain. And that's what the judge was saying. And then very finally, then, is this question of this secondary case, this freestanding illegality that is alleged. And my learned friend deals with this in his appeal skeleton. As I say, he doesn't raise it orally, but he intervenes to make clear that he doesn't give it up, and I wasn't suggesting he was, but the problem is that it becomes quite difficult to understand. If we can go, please, to page A42 and paragraph 110 of his skeleton argument, and I'll show you what he says about this case. This is the case that even if there's no incorporation, there's some potential argument that this is a void contract. And so he says this, 110 on page A42. It should be noted, however, that if the defendants succeed on the former subground, it is not necessary for the defendants to succeed on the issue of incorporation to overturn the judge's holding on the Sharia defence on appeal. That is because, as set out in further detail below, the defendants run an alternative argument that even if the AOFI standards were not incorporated in the Master Murabha, the contract could not operate, as under clause 4E, the parties were prohibited from entering into muraba contracts that were unlawful. Now, this is explained subsequently in a single paragraph at page A44, subparagraph. It's actually A45, sorry. In the context of estoppel and waiver and all the rest of it. A45, little paragraph 121, subparagraph 2. Secondly, it is submitted that even if the defendants are held to have waived their right to allege that the purported Master Muraba agreement is not Sharia compliant, they have not waived their right to allege it is unlawful. Clause 4E of the purported Master Muraba agreement expressly states that the investment agent shall only enter into a Muraba contract if it is not illegal or unlawful for the investment agent to enter into the Muraba contract. In circumstances where the Muraba contracts prescribed by the purported Muraba agreement do not comply with the AOFI standard, it would be unlawful for the investment agent to enter into the Muraba contract, the net effect being that the purported Muraba agreement is a nullity. So I have to say that is difficult to understand. It's difficult to understand what point is being made there. But what they appear to be saying is that each of the individual Muraba contracts was unlawful or illegal one way or another, regardless of incorporation. But we say it's certainly not pleaded. It hasn't been argued orally. There's no authority to support it, and it cannot be right. Because, as I say, the particular Muraba which operates is the third one on that construction. The first two have been repaid. My lords, that is all that I had to make by way of submission. If there are any questions, I'd be glad to ask them if my learned friend will allow me to. Grateful.
Nothing from me. Anything from my colleague?
No for me, thank you.
No? Okay. So, Mr. Fraser, your turn now. Thank you.
Thank you. My lords, thank you very much. Dealing firstly with agency. In my learned friend's submissions on agency, in answer to a sensible question posed by the Chief Justice as to how agency would surely need to be a matter of factual investigation at trial, my learned friend said yes, but the appellants needed to have a case. And made submission to the effect that the absence of pleaded particulars of agency and so forth meant that even now, I think he said, we had no positive case on agency. With all due respect to my learned friend, we in fact made our positive case on agency very clear to the judge below in our skeleton. I'll give you the references, paragraphs 106 to 107 at D, and at D 118 to 119, and at D 132 to 135, and orally by me at length over about 15 pages of transcript. E220.
No, what, Mr. Fraser? There's an echo. Somebody.
I'm just on technically. I really don't think there's anything I can do about this. Can you possibly bear it or?
Okay. No, not the whining. There was an echo just now. Okay, what he's saying is.
What I'm saying is
even on agency, you merely pleaded one sentence. It's an agent. There's nothing to.
Yes.
How did the agent? How was the agent formed? You didn't plead that.
I'm going to come to that.
Yeah.
I'm going to come to the pleading point once I've set out the case. And what I said is, we set out the case in our skeleton argument below. I set it out orally to the judge below over 15 pages of transcript, and again to your lordships in our written skeleton by reference to those arguments. And that's at paragraph 35. I didn't go through it at length yesterday, our case, because I was addressing myself specifically to what we saw as the judge's finding that we had no real prospect of showing agency because Norbank was plainly acting as the appellant's agent at the meeting. Of course, we have a positive case, and for the avoidance of doubt, in summary, it is as follows. As a matter of practicality, following Norbank's appointment as lead arranger on the 1st of August, Norbank inevitably was put in the position of becoming the go-between in communications between the banks and the appellants. That is the role of a lead arranger, and it happened here. In the course of this role, Norbank sometimes was speaking and acting for the appellants to the banks, such as sending out term sheets at D1204, or receiving commitment letters, Ali's witness statement, paragraph 41 to 2. Sometimes he's speaking to the appellants On behalf of the banks, and that's the chairman's witness statement of paragraph 27 at D1178. In all cases, they're organising everyone, and you can see that at D1208. That's the organisation schedule of the last few days. As I pointed out yesterday, there's nothing in the letter itself made it impossible for Norbank to be the syndicate bank agent for certain purposes during this process. Indeed, it is impossible at this stage, we say, to be sure whether during this process Norbank was acting at any one time with implied actual or apparent authority of the appellants or of the syndicate banks. But bearing in mind the McKnight passage that I took your lordships to yesterday about how things change going into stage 2, we say the inference that Norbank may have been acting on occasion, that is the negotiation, the inference that Norbank may have been acting on occasion for the syndicate banks must be stronger once draft terms were circulated, and we know that was in mid-November from Mr. Ali's witness statement in paragraph 42D50. And negotiations commenced over those terms and those drafts. As thereafter, Norbank will have been spearheading negotiations over these documents for the banks with the appellants, including those during those last frantic days, telling the appellants what the banks could accept or not, as that McKnight passage describes. And it is noticeable the respondents are not claiming that the banks have direct communication with the appellants themselves during this period. It's accepted it was all through NOR. So in these circumstances, we submit it's not fanciful that the banks, by consenting to Norbank spearheading negotiations for them in this way, appointed them as agent by implication for this process, implied actual or ostensible authority to negotiate for them. And they are thus bound by what Norbank says at the meeting, even if Norbank went beyond their brief. Furthermore, as the December the 16th meeting was slap bang in the middle of this frantic period of negotiation, and the purpose of the meeting was to extract further security from the appellants to enable the syndication to go ahead, it simply cannot be ruled out in our submission that a judge might find at trial that Norbank arrived at the meeting cloaked with implied authority or ostensible authority of the banks. Now, my learned friend also said that none of this agency business makes sense if Norbank came to get the security for itself, as indeed transpired. However, we say that misses the point that the security was being extracted so that Norbank could release its own security over the Moderat camp to the syndicate banks to enable the syndication to proceed. So seen like that, its demands were indeed, as I said yesterday, for the benefit of the syndicate banks. Now, your lordship doesn't have to take my word for that. This is actually the evidence of Norbank before you. If we just pick up D52, in paragraph 51 of Mr. Ali's witness statement, when he's explaining the withdrawal threat, paragraph 51, I'm so sorry. When you'll see that paragraph 51 in discussing the threat, that is the wrong way around, is our allegation to say what they were doing. Norbank wanted a bilateral agreement to cover its exposure, but the purpose of that bilateral agreement was to give Norbank sufficient comfort to release the security it had taken under the bridge facility, the security over the Mujamat camp, for the benefit of the syndicate, not to prevent that security from going forward. That's their evidence. So my learned friend cannot say that Norbank taking OBN security was not for the benefit of the syndicate, when that is precisely his own client's evidence. So it's not improbable, we say, that Norbank was sanctioned by implication to make its demands of the appellants, or at least make such demands during the course of its applied authority. Indeed, who knows? Once we have proper disclosure from the respondents going forward between themselves from this period, we may find, and I can't plead it now, there was express authority for them to make this demand. We don't know that because we haven't had all the documents, and that's the Doncaster Pharmaceutical points. But not wholly incredible to suppose that the banks may have had a conference telephone call or a group email discussion that Norbank informed them they're going to request OBM from the appellants so that it would continue this in the syndication for the benefit of the syndication as a whole, and the syndicate bank representative said yes. So, of course, the chairman's evidence, untested by cross-examination, is that Norbank at the key meeting made specific representations and promises on behalf of the syndicate bank, and that's paragraph 41 and 42, including the promise of 350 million from them, which he tried to get to increase to 450. So it's not determinative, it's as support. So whether or not, and obviously don't forget the point that under the terms of the Common Terms Agreement, they would argue have had to share the benefit of any extra security with the other banks anyway, as they've been advised they had to do so. And that's at D2970. So stepping back, determining agency is, of course, a matter sensitive to the facts of each case, and things will be clearer at trial. But we submit that on the basis of the above argument, it should not be ruled out now on a summary basis that Norbank could not have had agency on behalf of the syndicate banks in making these statements or appeared to have such agency. A couple of other points picking up my learned friend made. He says, well, there's an inconsistency between this agency case and our duress case. We say there is no inconsistency. Whatever the chairman's own understanding, which would support ostensible authority, it is common ground that Norbank, as a matter of fact, indubitably ended up with the ABN security itself and thus breached its own best efforts obligations under the 1st of August letter by its threats and actions. Now, he also pointed to the chairman's evidence, paragraph 54 of his witness statement, which was to the effect that, and we can pick it up, at D1185, and he said there, well, when I complained about at that meeting the banks had security, but they hadn't provided me the working capital, when I mentioned OBN, something strange happened. They appeared not to know about it. Of course, it's a contraindication of Norbank's previous agency, we accept that, but it's not very determinative by itself. Those particular syndicate bank representatives of the meeting in December 2019 may not have been party to the syndicate bank Norbank communications a year earlier in December 18, prehistory, as you might say, and so unaware of that Norbank taking the ABN security with other syndicate banks' blessing, or unaware generally of their agency status. Furthermore, even if it turns out the syndicate and banks were unaware that Norbank was taking the ABN security, and Norbank acting outside of its apparent or usual authority, it's trite law that syndicate banks can still be fixed with liability for Norbank's actions of acting within the usual course, and that's posted 3004 at F1720. Now, my own friend and the Chief Justice raised the pleading point. He is quite right that, of course, paragraph 55 of our pleading was bare of particulars and would have been susceptible to a strikeout application unless further particulars were given. But this, of course, this was not a strikeout application under Rule 4.16, but instead an application for immediate judgment under Rule 24. Had it been a strikeout, we'd of course have met it with a revised pleading. As it was an application for immediate judgment, we met it with evidence and argument instead. The judge below understood this as well as Peter Grace, we say yesterday, as he addressed our agency arguments in substance in rejecting our case and did not base it on the pleading point alone. Accordingly, if your lordship consider that our agency arguments, as I've outlined to your lordship, have a real prospect of success or not, of course your lordship should, in a case of this magnitude, overturn the judge's decision on this point and, if necessary, direct us to file an amended pleading to reflect the points that I have made as part of any directions for trial your lordships may give. Furthermore, if your lordships consider that the culpable statements may have been made by Noor on the 16th of December, such as Norbank should account for them at trial, why is it right that the other syndicate banks should avoid having to account for them also? After all, as Kazim Ali said in his witness statement, they were made for the benefit of the whole syndicate. And indeed, the syndicate had taken the benefit of Norbank's actions in the form of the subsequently completed syndicate facility agreements with improved security for their existing facilities. Surely they should be at this trial also, case the appellants are indeed right that Norbank acted as their agent in making such statements. If these substantial banks have taken the benefit of Norbank's action, surely they should share the burden of facing the trial also. It would also, as we said yesterday, particularly unfortunate if your lordships had declined to overturn the judge below's findings on agency, but did permit our counterclaim Norbank to go forward, and we were then to have a mass investigation of the facts surrounding the key meeting. During the course of that investigation, discover all sorts of evidence and emails showing that Norbank was in fact acting as agent of the syndicate banks. One, as I say, one mass email, group telephone call. A real injustice would have been done and been shown to be done. If your lordship has any doubts in the agency issue, better to resolve in our favour today and send them all off together to find out what actually happened, rather than dispose of it in an uneven way today. In the end, my learned friend cannot get away from the Chief Justice's factual investigation point. The question of agency is always a matter of first establishing all the relevant facts before then applying the legal agency principles to get there. We haven't nearly got to the first stage of establishing all the relevant facts on this mini trial. Only a trial judge can do that. What we can submit is that, unlike the judge, your lordship cannot dismiss as impossible that agency may be found at trial. And then turning to my learned friend's points on the other grounds, our main reply point is to similar effect. In each case, my learned friend made some attractive points, but he was unable to find an answer to the Chief Justice's point that all of them, in varying ways and for varying reasons, require a full factual investigation at trial to be determined, especially if your lordships consider the events of the 16th of December meeting themselves need investigating. On affirmation, round 2, we'd need a factual investigation of the circumstances of the appellant's affirmatory acts in March, July 19, and whether, and if so, when the appellants can be fixed with knowledge of the respondent's breach prior to then. Specifically difficult when, as we say, when the question of working capital was still live throughout 2019, were they going to supply or not? Had any breach arisen? My learned friend is asking your lordship to infer from the fact that we had counsel that we must have known. But the authorities are dead against my learned friend on that. They all say the investigation needs to be done at trial. On duress, as I made clear yesterday, to understand what the meaning of the best efforts clause and whether it was breached by the events of December the 18th, we need to investigate the factual matrix of both time periods. As to MARM, on the question of the interdependence of the contracts, my learned friend didn't really push. That question of substantive independence would involve looking at the factual matrix to determine the relationship between the two contracts in the parties' eyes, and indeed whether NB acting as a Norbank acting as agent for the syndicated banks and its actions. Obviously, the events of the 16th of December meeting, ground 6 as well as ground 4 and 5, are all require massive factual investigation over an 18-month period to ascertain what was said and by who at that meeting, and whether those statements amounted in those circumstances to implied misrepresentations or enforceable collateral contract. Even on the Murabara, again, whether the OFI standards incorporated into the syndicate facility agreements as a matter of construction, whether there is any subsequent breach of those standards and the consequences of that breach to the Islamic facilities, plainly a substantial investigation of factual and Sharia law matrix abound of Master Murabara and assisted by expert evidence. All of which we say underlines my opening submission that this was a substantial, if not massive, commercial case, bristling with legal and factual issues that should have been determined by the judge on a summary basis and should now be sent to trial by your lordship. I've only got a few points on the individual grounds beyond that I'm just going to pick up, and I shouldn't be too long. On duress, I've made my submissions on the best efforts clause and how that could have been breached. Your lordship, Sir Robert, asked for a counterfactual. I said, best efforts, maybe they could have done something else to achieve what they wanted, and this what they did was not best efforts. And Sir Robert asked, what would be a counterfactual? But one counterfactual is they could have sought the OBN, but sooner security. For example, part of our complaint, it was sprung on the chairman at the very last minute, last few days, in circumstances where Norbank had him over a barrel and there wasn't time to raise finance from elsewhere. Had Nor made clear they needed security sooner, the chairman may have been able to make another plan and obtain lending from another bank that did not need to require the ABN. But it's in the matter of days. What could he do? And there is evidence that as early as August 2018, persons within Norbank wanted to lower the amount lent, but there doesn't been no indication of this was given to the appellants until December, the middle of December 2018. The appellants could have explored different solutions. Alternatively, instead of seeking securities, the question of course, credit risk insurance. Might have been chunky, but premiums, maybe that would have been a way we might have been able to help with premiums on default on our position. There are alternatives, experts will look to it, but Sir Robert asked me for some counterfactuals, what would have been the different options. So I've just given those ones.
Answer to Fraser that we don't do knighthoods in Australia since some recent embarrassments.
Sorry, you don't do
knighthoods in Australia. Thank you anyway.
Knighthood. Knighthood, no knighthood.
Well, I won't say anything now. So that was that point. Marm on duress, my learned friend didn't really push that. I think he must acknowledge that he and the judge got to the wrong principles. We refer to our skeleton, paragraph 71 to 76 on that. Misrepresentation. The only question there really I wanted, because it's clearly troubled your lordships, is on the question of must have been a fraud or fraud or bust. My learned friend's submissions on that. And we don't quite accept it in that way. And what it's probably best if I pick up a document which is right on the day or the day of the meeting to show you how nothing is settled. And so had it been a claim of fraud, let us say, in the converse, the syndicate bank sort of said, or Norbank would have said, well, nothing's settled. How could you say that we had no definite intention? I was making counterfactual, another counterfactual. I was making a claim of fraud. I said, how can you say it's not settled? We might have done. Who knows? And so the same thing would apply the other way around. It's very strong to say it was absolutely settled and therefore it was definitely fraud or not. We're saying, you know, you can have lower down the scale. It's just not quite fraud, but they didn't really have reasonable grounds for making the promise. So that's really it. And if I could just ask your lordships to pick up D 585, because my learned friend did take your lordships to some documents around here, but they didn't quite take it to this point, and so it would worth 5 minutes on this point.
We are in reply going to documents that weren't actually referred to in the submissions, but there we are. I mean,
no.
I'm quite sure about pointless.
Perhaps my own friend would just let me finish. It's not going to be very long. My own friend skirted around this document, but didn't actually sufficiently. We start at D585, which I think actually he did go to, Mohammed Naqvi on the 16th of December, in which 2008, in which he puts forward the credit proposal, which is renewed from the August, the summer credit proposals, updating it. That's Mr. Naqvi from the syndicate team to the credit team. He's from the credit team within Norbank. At 584, you'll see the response my learned friend took your lordships to, and he said that the approval back in the summer was on the basis that they would, the BEC approval on the basis that would be reduced to 250 million in the syndicate, and in case it isn't successful, we will continue and aiming for a reduction. In discussions last week, syndicate team ensured us reducing exposure by April the 14th. He copies Hamid Butt. Hamid Butt's response is just above, which lordships weren't taken to, and that at 2:48 p.m. says, Umar, I'm not privy to what you communicated to the BEC. However, my email of July the 24th, which is appended below, and I don't need to take it to you, but it's at page 587, did not state the syndicate will reduce the exposure at close for reasons that I thought were clear. I also noted there was no deadline asked for reduction, and his email is a lot more positive about the credit, put it that way, and he's positive that no deadline had actually been set. So, and then above that, at 583, Umar responds by explaining that the reduction strategy in the credit approval was in the credit approval, and that the data had come from the syndicate team from this. Now, two things from this. There's a division between the syndicate team and the credit committee within Norbank over whether the credit needed reducing. And on April the 14th date was being circulated as a possible reduction date. Looking at therefore the issue before us, Norbank syndication team making the working capital promises later that day at the PAR meeting may not have known that Norbank would not for sure, for fraudulent purposes, honour any purposes. They may have thought they might honour the promise by April if the term lending has gone down. Indeed, if the extra security of OBM was obtained, it's easy to see how the syndicate team might feel more confident. Given the opposition, however, we would say they did not have reasonable grounds for doing so. That's the claim, and it's a reasonable one. It doesn't have to be fraud, and I think I hope that I've shown your lordships that without having to go any further. On the collateral contract, my learned friend was keen to say, well, there isn't any part performance because it was just a promise of the lending. But actually, the working capital promise it did involve us providing the security as part of that. And your lordship might get that at C39, paragraph 62B. 62B, this is the summary of the statements, beginning, if the chairman did agree to security in respect of OBMs being provided, the ex-claimant would ensure the working capital would be made available. The chairman did provide the security, they did not provide the capital, and that's what the authorities are about moral purpose. If it would be wrong to let a party take part performance and welch on their side of the bargain, and hence they'll go the extra way to construe a contract. On the questions of ground 6, I don't think the lordships will be assisted by any more documents from myself or on this issue. You've seen quite enough. I simply say it's fairly obvious it's an unclear issue. It needs investigation at trial. On the Murabara, just on the question of the office standards, my learned friend said that, well, by reference to the standards at F1636 themselves and the commentary at 1644, he said the standards may say what they say, and our expert says that what has happened offends those standards, and you make that what you will, but he is an expert and that's his opinion. So we say it raises the case. And he says, however, there's a let-out of 164, monetization may also be used in these circumstances after ensuring they have developed genuine intention, and maybe, but that's not the that's something my learned friend has to rely on. It's not for us to make that case. We rely on the strict terms of 3.2. So it's not for us to make that case. We would submit. In the question of the discretion of the judge to proceed in the absence of expert evidence, we would grateful for your lordship pointing us in the direction of Nest, the Nest case very recently. We would rely on that in that respect, because what it does is it confirms the discretion. Oh yes, this is important. On the question of the registrar's direction and discretion, I nearly intervened, but I didn't, because I didn't want to interrupt my friend at the end. We don't accept it has no legal status, the registrar's directions. I mean, of course it has status. Otherwise, what would the participants in the courts in the DIFC do? That was this thing had no status. It has status. We say its status. It gives the judge still has a discretion, light of fidelis judicia or confirmed in Nest. But because of the registrar's direction sitting up there on the website, it must be participants, users of the courts, must assume that expert evidence will need to be adduced to make your point, unless there's a good reason otherwise. That's the point. And we think that, and in Sharia, in Nest, and I've got it now, at 1950. Paragraphs, it said Fidelis Felicio does take you quite a long way, but it's all a matter of discretion. And importantly, I think it's if the relevant judge has knowledge of that international law, then the discretion would favour carrying on. But if the relevant judge is not an expert in this law, as the judge, Justice Jeremy Cook, is not an expert in Sharia law, then discretion must tend towards the other way. And for the reasons we give in our skeleton argument, we think that he got his exercise of discretion wrong in that respect, and that I think is where we get to on that. On the waiver of submissions, we made our submissions in paragraph 121.1 of our skeleton argument, and why public policy would offend against that. I just want to do the question of nullity because it has caused some confusion. It is accepted that it is not pleaded. It is was referred to in our skeleton argument below in paragraphs 223.5 and 231, which is at D 1583 of the bundle, D 1383 and D 1385, and it's obviously in our skeleton. What it goes is this: if you pick up D clause 4e, it all surrounds clause 4e at D682. 4e of the master murabba. And there, it says, without limiting the provisions of clause 2.1, the purchaser may only deliver a transaction request, and the investment agency, as an agent, that is, NUR, shall only enter a murabba contract related to those commodities if, and it sets out A, B, C, and then D, and then E, if it is not illegal or unlawful for the investment agent, that's NUR, to enter into the murabba contract. Now, the argument here is whether or not the non-reliance clauses stop a complaint about Sharia law, they can't preclude a complaint that the subcontracts are illegal because clause 4e prohibits the parties from entering into a subcontract which it would be legal for Norbank to enter. And on our argument, it would be illegal for Norbank to enter the subcontracts under Sharia. That's the point of the breach of the AOFI standards and how you get to illegality under Sharia law using Edge paragraph 14. An argument, we say, not conclusive at this stage. Now, there is, of course, a tension between the non-reliance clauses and clause 4e, and how they are objectively intended to interact would be exactly the sort of factual issue which an investigation at trial would be more suited to resolve. You could argue, for example, that the clauses are addressed at different scenarios. Non-reliance clauses intended to avoid a situation where a party is entering the agreement knowing them to be Sharia non-compliant. In these circumstances, non-reliance clauses effective to stop them complaining. And clause 4e here intended to stop a situation where parties unconsciously entering an illegal contract, including under Sharia law, in which case both parties would wish the contract to be void. It was not wished as respectable UAE businesses to enter into any illegal contract. And that may be exactly what's happened here, unconsciously illegality rather than deliberate. Now, my learned friend might say such illegality here was not meant to include Sharia illegality in light of the recital D or clause 13, the non-reliance clauses. However, there is no carve-out in clause 4e, if you look at it, for Sharia law illegality. So your lordships cannot assume that they are right, at least not at the summary stage. The tension needs to be investigated at trial and against the factual matrix known there. And that's how he puts it. And that is half an hour, as I said I would.
Okay, thank you very much.
All right.
Thank you very much, Mr. Fraser.
Thank you so much.
Thank you very much, Mr. Montague-Smith. I think we're going to get some time to come up with a decision, you know.
Okay.
And the case has been going on for quite some time, since 2020. So give us a few weeks to come up with a proper written judgment. And yeah, Mr. Peter, yes, Peter? You have to say something?
Well, apart from my thanks to both counsel, Chief Justice, have you got a few minutes just to hang on the phone?
Yeah, sure.
Now,
sure.
Thank you.
Yeah,
I know it's very late in Australia, but
okay. Mr. Robert is.
I'll back off.
We'll all drop off. Thank you very much.